track. And you should have kept my name out your mouth. Fast ego, how it all turned out. When you try to use my name for clout, keep on going, give you something you could talk about. Throwing all the good vibes out the window. Somebody come hold my cup. A squirrel is acting up. Seriously though, do you think it's a medical condition? Maybe it's demons, I really don't know. She cracking up. They ain't right. Hello, everybody. Hello, everybody. Hello, 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 hello. Just so you are aware, I do have a music channel. I know there's been a lot of uproar lately about AI music and this and that. Just as soon as anybody wants to feature me on their Brick and Minifigs song, girl, I can rap, I can sing, I can be cute. Okay. So I'm happy to be on the Brick and Minifigs song. I know y'all are gonna ask me about this brick by brick shirt. Please do hit your like on the way in. Hit the like on the way in, on your way in. This is actually merch from my brother slash cousin Tough Stino. He's another YouTuber. We crossed paths when we covered the same, a similar topic and some of the same topics over the last year or so. So it actually has little bricks on the back. I bought this with my own money. This is not sponsored, but the last time I wore this shirt, y'all went crazy and were like, where do I get the shirt? So I did link it down below. Again, this is not sponsored by me in any way. I get nothing out of, like, no money or anything out of this. But there's like different colors. This is the exact shirt that I'm wearing. This one, I did not get the white or the butter. I got the color ivory in a size small. I probably would get like a medium now. But small is fine. But yeah, that's where y'all can get this shirt. It's actually merch from like another YouTuber. Like I said, I know we've covered this some of the same topics. So if you want this brick by brick shirt, it does have a little stack of bricks on the back. It actually he has been saying brick by brick for a long time, even before this Lego stuff. But now I've been, wearing the shirt more because of that. So it looks like some of y'all actually did order it already. Of course, I like to support my friends. I like to support other creators. I have thought about making brick by brick merch, but I think I actually have something better in mind. And when I make this merch, y'all better get it. Okay. It's going to be limited run. I don't make merch that lasts forever. I do limited runs because this is a small operation over here. I can't be just having unlimited shirts getting printed out and things. Anyway, I have some things in mind. I have some things in mind just to commemorate, our time spent together on the Lego story and the Brick and the Minifig story and Reckless Ben and its whole progeny. So it seems like every single day I either go to sleep at night or I wake up in the morning and I think, all right, today's the day where I have to split up. I have to split up the Brick and the Minifigs coverage with something else because I'm really actually ready to start covering at least something else, putting in, a different little topic here and there. I don't want to turn into the Brick and the Minifig channel, but girl, every single day there's something new, there's something exciting, and there's something that I got to cover. So today it does look like we're going to be covering only all Brick and Minifigs, but y'all don't get used to it because it is my intention. It is my intention to start phasing this out as being like the thing I cover all day for 5 straight hours a day or whatever. So, carpe diem, as it were, and also strike while iron hot, as it were. There's times that I end up, that sounded so country. There's times I end up, sometimes my roots come out. Always check the roots. There have been stories that I've covered in the past that are kind of like all consuming for a while, for a couple weeks or a few weeks or maybe a couple months, and then they just float on into the forgotten land. And I've been doing this job for long enough now that I do recognize that while there is, immense, not only public interest in a case, but also actually stuff to talk about, eventually it does always fade. So I am trying to, what's the word I'm looking for? Lean in, seize the day, seize the moment, and just really go all in on this story, which I do feel like I have done. I never, ever, ever, ever check my, what's it called? Analytics and stuff. Like back in the back end and all that. I really don't ever check the analytics other than maybe I'll put out a video and there's like a ranking. I don't know if y'all are familiar with this or not. If you put out a video or whatever, there's like a dashboard for creators, and then it'll show you a ranking of your most recently uploaded video. So it'll say like, let's say I just uploaded a video last night. It'll be like how many views it is. It'll be like 2 out of 10 or 3 or 1 or 10 or whatever. And that's pretty much the only analytics I check is that like main dashboard. And then it'll tell you like the supposed estimated money that the channel made in the last 28 days. Other than that, I don't really be going into the back end. Like, I don't really be looking at like, oh, this video did the best, or this type of style of video did the best, or this topic. But I put out a video last night that skyrocketed. It did really well. And so it actually made me wonder, like, why did that video do so well? It was the one, I'll show y'all which one it was. I just put it out. It's the most recent one on this channel that's not alive. I think it's something about the statement Bricks and Minifigs made, which we will talk about later. But this video, I mean, I posted 14 hours ago. It's got 32,000 views. That's like a lot of views for the videos that I post. And so I was like, whoa, like that's a lot. So that kind of prompted me to go into the back end and look at like how the videos that I've posted on this is a new channel too, by the way. This channel that you're on right now, I think when I started covering the Bricks and Minifigs situation, I had about 10,000 subscribers or something like that. And yeah, I was cussing them out. I know, girl. So this is like a new channel. I just started it in the spring. I believe it was March. So like 3 months ago, I started this channel. So I am kind of like curious about the videos and things like that. So I go into the back end and I noticed that the videos that performed the best, which again, I never look at this type of analytics, but the ones that performed the best were the live streams where I was getting into this very obscure, some might say nitty gritty, like the Legally Mine, the Veil Corporate, the Search Warrant. Like y'all really liked those the most. And that's kind of encouraging because that's the type of stuff I like to do. But most of the time in my experience of doing this job, I would do that type of detailed evidence gathering and investigating off camera. Sometimes maybe I would indulge into like 1 or 2 lives, but it's actually been pretty cool to see that the videos that actually have done the best on this channel over the course of the last, month or whatever, have been those ones. Like y'all like those the most, the Legally Mine and the lawsuits and like the stuff that actually technically doesn't really have anything directly to do with the story, like the dad and the son suing each other and all of that. I mean, all of it obviously does relate to this story because Dan McNeff specifically used to be the CEO of Bricks and Minifigs. He even has now come out and publicly admitted that on his public Facebook page. But it is really cool that y'all like that. I do kind of sort of feel like it's taken me like, 6 years online, but I'm starting to find my people and y'all are starting to find me, where it's like, no, we like the details. We like to go into the details. And, come what may. Yesterday, I kind of did get a little bit curious. I don't know. I don't want to say discouraged, but it does pique my interest when, yesterday when I was on live, it was once the number got up to, like 1,600, then it would drop down and go to 14, and then would drop down and go to 1,200. I'm like, I guess people don't really want to sit here and watch this body camera footage. So maybe I'll just do it not on live or whatever. But then I go back to the back end last night and it was like, no, y'all really liked the body camera footage the first time. So it was just more confirmation to just pretty much just keep taking each day at a time. And I don't want to be beholden to any one thing. I want to be able to move, like water, as it were. I want to be flexible. I want to be able to cover other stuff if I want to. But like I said at the beginning of this little monologue, this is just a check-in. I know like people do think my live streams are like too long and stuff, like some people do, and so sometimes it's like, oh, maybe I should be making shorter videos, or maybe I shouldn't be doing these check-ins and monologues. But actually, in the days of AI, in the dawn of AI as we are in, I'm gonna just double down. I'm gonna double down and take it a long time. It's like that is an art form that people don't do anymore. Sometimes it's like the performance art of the stamina, that it takes to be live this long and things like that. I mean, I wouldn't consider myself to be a performance artist, but there is a sort of rarity. Anybody can come on here and make a 10-minute video, although there is a skill to that as well. I'm gonna just keep doing my thing. I'm gonna keep saying what I want to say. I'm gonna keep doing my little 30-minute extended monologues if I feel like. And I appreciate y'all for staying around, sticking around, and um being around for it. So that's pretty cool. Streaming is hard, yes, especially since I don't know if y'all noticed or not. I got this new light a few months ago, and it makes my videos like obviously look more professional. It's like this huge light right here, but y'all, I am photosensitive. Okay, it's on setting like 3 out of 100, and it is so bright. It's not a LED like I do have an Elgato light over there, but this one is like a big box, like a soft light thing. And it was a big investment for my little set and stuff, but like y'all, sitting up under this light is very difficult. Sometimes I'm like, oh, I know why streamers wear sunglasses. But yeah, I'm also starting to get like wrinkles on my nose from squinting like this. You can't really see it because the light is good and it diffuses the texture, but you know, it's all part of the game, right? Okay. So I do drink water. I do drink water. Does American Fork have flock cameras? I don't have no idea. Okay, so yeah, I do have a music channel. It's called Gorianna, and that's what that song was from. It's better than changing LLC every 10 minutes. Well, there are going to be some changes on the horizon over here, but nothing that's going to be bad. Okay, so yeah, I totally agree with this, Captain Yuzu. If it's too long, then a solution could be maybe leaving the stream. Yeah, they can leave. Um, Apparently, there's a way to check if there's flock cameras. Someone said you could check on deflock. Nice. Okay, so all that to say, we definitely do have a lot to get into today. Since yesterday, there's been actually quite a few updates. We are in a pretty, it's a little bit of a paradox, okay? It's a little bit of a contradiction that we are existing in right now as the members of the public who are following this case. Because on the one hand, kind of like nothing's happening, because the major players in this case, at least the defendants, the people who have been sued, are not able to talk. And even people who are not named defendants are afraid or trepidatious to talk about the case. And so in a way, we haven't seen part 3, and I think it's being reported now that there's going to be a part 3, a part 4, maybe part 5, 6. As long as stuff keeps happening, then Ben is going to have to keep documenting what's happening, right? So in a way, it kind of feels like nothing's happening. In a way, it feels like we're in this purgatory where Ben can't talk. He can't make part 3. We all want to see part 3. But at the same time, a lot is actually happening in other ways. So that's why I say it is a little bit of a paradox, because there's a lot happening, and I'm sure that there's way, 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 way more happening behind the scenes that the, actual plaintiffs, defendants, people involved in this story actually know that the public doesn't know at all. So as I told y'all when I first got involved in this coverage of this story, the reason that I got involved primarily was because of the tyranny and the corruption that I personally saw on the body camera footage having to do with American Fork Police Department. And I'm talking about up and down and all around. Like the fact that the redactions ended up coming out, and even before the unredacted body cam footage was leaked or released or whatever it was, like even before that, Ben had access to different body camera angles from the same incident, and he was able to see that sometimes the American Fork Police Department records people, they would redact stuff on one camera and not on another one. And even there, we were able to see that they were kind of like nonsensically redacting stuff, or possibly even in violation of the Utah statutes, redacting stuff that basically just made the police look bad. But then after that, very shortly after that, the unredacted body camera footage was unleashed upon the public. Now that wasn't, I do forget this as well myself. The unredacted body camera footage that we do have access to as the public is all is not all of the incident. It isn't all of the body camera footage. It's just like a few days of the 3 days or whatever, or maybe I'm not exactly sure, but it's not like all of the body camera footage. We also don't have any body camera footage from Kaiser, which is where this whole incident started. And so when I got involved in covering this case at all in the beginning, it was because of the American Fork Police Department acting a damn fool. Then shortly after I started to learn about the case and kind of make videos, I mean, like within a couple few days, I don't even remember the timeline. I should probably add that to the timeline. But then Ben was pretty much silenced with a temporary restraining order, and he wasn't going to be able to make part 3. And I had been also similarly, although, I've told this story many times, I'm not going to get to the details, but I have similarly been unlawfully, unconstitutionally restrained with a temporary restraining order in a state that I don't live in. And during that time, there were a couple few creators online who did step in and kind of, I don't know. I mean, maybe I would characterize it as carrying the torch, keeping the story alive, because the whole point was the people who were trying to silence me did not want anyone talking about the story publicly. They wanted it to go away. They wanted to punish me and, in my opinion, harm me and my rights, and they wanted to scare other people away from talking about the story. So for me, it was like this 1-2 punch where it was like, the police are being tyrannical, which is something I've covered for years. Actually, my first story that I ever covered at all, period, ever, before I even showed my face online, before I even knew how to, I mean, I always showed my face online, but like when I was reading court documents and stuff, it would just be the court document on screen. This was before I even knew how to screen share. And this was to expose government corruption, the police and the courts. And so that was Free Britney. That was the first thing I ever really covered as at the time, lawyer. I hadn't even taken the bar exam when I first started. So many things have happened. I feel like I've lived lives in the meantime. But then it was like, I got into it because the police were acting crazy, and then Ben was silenced. And so he's been silenced pretty much ever since I've been covering this case, and I've never spoken to him. He's never reached out to me. I don't frankly even know if he knows I exist. And that's not the purpose. It's just, those are the kind of the reasons. And so, yeah, I'm over here in my lane. So I don't know. I just wanted to do a little bit of a check-in. I mean, the last time, the last live that I did was yesterday. And when I was getting off, I was kind of like letting y'all know, look, I'm not going to be covering this every single day for the rest of my life like this. Like, this is going to be, I'm not going to say I'm tired of this case, because I'm not. There's so much more to learn and know, but I do kind of feel like I'm like neglecting other very important things and topics. But anyway, that's the check-in. And for now, we're just going to keep on keeping on. So we do have some movement in the case, even since yesterday. I do want to actually today also at some point circle back around to 2 things that we did discuss yesterday, because I want to fill in some blanks. So we have some new court documents in the federal case. Nothing too substantive, but I do want to show that to y'all. I want to keep you updated on the court documents and the court docket movement on these 3 cases that we do know about. I also eventually want to get into the Crystal Law, Ben Gorman lawsuit against Bricks and Minifigs. I have never even touched that lawsuit yet, because there's just been so much other stuff that I've been like, oh, I got to get to that first. But I do eventually want to get to that as well. But for the purposes of what I've covered so far on this channel, we really have focused on 3 major primary lawsuits, and that is the 2 criminal cases and then the 1 civil case, the RICO case that has been filed against Ben, Brian Mansell, and Victor Wynn and Reckless Ben LLC. Okay. So those are the three court cases that I am still, primarily talking about when I say the court cases we're following. So I want to show y'all some of the new filings that hit the docket in the federal case, which started out as a state case, and that was the one before Judge Graff. He's the one that implemented that wholly unconstitutional, in my opinion, temporary restraining order that is sort of, I mean, as far as I can tell, kind of like still in place ish. But I anticipate, I mean, today's only Tuesday. I anticipate that restraining order will be either removed, deleted, or revised. Something will happen. I anticipate probably this week. That's just because it's already been in place for so long. Federal courts especially do have a presumption against especially prior restraints, like telling somebody what they can say in the future. That's kind of like a minority report, and the federal courts are like not usually like too excited to be putting in prior restraints. And also, generally, from what I can tell, they're not usually that excited to tell people to take videos down either before it goes to a jury or at least a trial. So, based on those reasons, I do believe that the temporary restraining order will either be dismissed or taken away or severely modified this week. I think it will be. I could be wrong because stuff in federal court also don't move that fast. Okay, so what else? We have some new court filings in the state civil case where the case came from. I want to take a look at those. I also wanted to update y'all that I have several public records requests in the works right now. These, a lot of times these take a while, especially if you're requesting body camera footage. Just to prepare you, a lot of times when you are requesting body camera footage, a lot of stuff will be redacted that probably shouldn't be redacted, but you kind of get what you get. You don't throw a fit. So the public records requests that I do have outstanding right now relate to Dan McNeff reporting that people were throwing things through his big picture window. I also put in public records requests for Josh Johnson's handwritten reports. Now, these I have the least faith that we are going to actually be able to get because, for one, we already know the American Fork Police Department shows favoritism to Josh Johnson. We already know that the American Fork Police Department has already redacted records when giving them back to Ben, for example, in ways that pretty much take out a lot of the important information. Another reason that I think we might have an issue getting Josh Johnson's handwritten reports is, first, girl, I don't even know if you could spell. Can you spell bricks and minifigs? And yeah, bricks and minifigs. That's not how you spell, Josh. Please. But anyway, like, let's just say he can spell and he did write those up. A lot of times, like in, for example, Baton Rouge or California, Los Angeles specifically, if you request something that's like currently or possibly going to be under a criminal investigation, they won't send it to you. So I think, they might try to use any and every excuse, but specifically, and we will see this most likely if we do ever make it through all the body camera footage, that Josh was handed a clipboard by the American Fork Police Department and told to write a handwritten statement. I did request at least that one and any other handwritten statements that Josh Johnson did put forth. And I also, for the third public record request that I do have outstanding, that is with the Kaiser, Oregon Police Department. And that is for the records related to Brian Mansell. Put one in the chat. You remember Sheldon had a police report and he was like, I actually had access to this for a while through a FOIA request or the Oregon version of the FOIA request. So I basically requested that and any extensions, amendments, supplements. It has been widely reported. I think it was Sheldon Norcross who came out and said it was either him or maybe Brian in an interview. I don't remember now. I mean, I'm just like taking in information about this case all day, every day at this point. But I think it was Sheldon who said that police report is now like up to like 30 pages or something. So I did request that from Kaiser, Oregon. It is the holiday week. So anytime you're requesting something from the government during some type of holiday, expect it to take longer than usual as well. So I did want to update y'all that I do have at least those records requests outstanding. Again, that's Josh Johnson's handwritten reports about these supposed trespassing incidents in American Fork. This would be related to the Utah versus Reckless Ben case. I also requested the Dan McNeff records where he claimed that people were threatening him, bomb threat, death threat, all this and that. And of course, if that is true, the people who did that should absolutely be prosecuted to the fullest extent of the law. That is not the purpose of my videos, that's for sure. And anybody that is who is doing that type of behavior and activity has no place in civilized society. So you can dislike somebody, but we're not going to be doing death threats and bomb threats. That's crazy and illegal and criminal. So he did make those allegations about his, there's being people up on the hill looking at binoculars. I don't know why I always say binoculars. That is, no, it's very unsophisticated, girl. And then the third one is the Kaiser, Oregon one. Okay, so Josh Johnson's handwritten reports. That would be Utah versus Ben. That's American Fork. Daddy McNeff, Dan. And I also requested the body cam and then the Kaiser, Oregon ones. Okay, so I wanted to update y'all that I requested those things, and you'll be the first to know if I ever get any of those. Okay, we have some new court audio as well from a hearing last month. I want to talk about some more reporting that did happen actually yesterday on the story. I want to circle back around to some of the things we covered yesterday in the Wall Street Journal article, as well as in the Bricks and Minifigs statement. There's a couple things that I missed yesterday that I wanted to clean up today. I want to look at the BAM map. They also did a fact check that was really excellent. Okay, so those are some of the things we're going to do today, and then a couple rumors and thoughts and theories from Reddit, and after that, we may, if we have time, get into some more body camera footage, which we are on a little bit of a tedious mission to follow the case through from starting on March 8th, which was kind of like the first day that this stuff all kicked off in American Fork, and then escalating to March 11th, which is when the unconstitutional raid based on an unconstitutional search warrant did occur. We may get to that. We may get to some of the body cam footage today. We are now on March 9th, so we have a while to go. Thanks so much to Tommy Cat for becoming a new member. Thank you, Player Profit, for the $2 Canadian. Follow your heart. I'm here for it all. Keep it up. Thank you. Thank you. Thank you to Big Crunch. Too much BAM coverage? I don't think so. For the $1.99 super chat. Big Crunch, that's whose amazing, awesome Legos collection we saw yesterday. And thank you so much, and thank you for sharing that. Thanks so much to Amber for the $4.99. Appreciate what you do since 2021, I think, is when someone mentioned you in another live. Justice for Amanda Rabb. Indeed. Thank you. Thank you, Father McLeod. WWE Superstar quality opening today. Okay. If possible, add a ramp and start from behind a curtain. Probably not doing that. Thank you for the $5, but I do appreciate the vision. I am just about extra enough to do something like that, though. Thank you so much, yeah, for the $4.99. Are there ever consequences for redacting videos that obviously should not have been redacted when they were obviously just protecting cops? Short answer, yeah. Technically, yeah, there are sometimes consequences, but as you probably are aware, it is very difficult to hold law enforcement especially, but any government agency accountable for violating the law. So, I mean, yeah, sometimes people are able to sue. Usually this is going to come in the form of like a mainstream media source like a New York Times or a Law and Crime. There is a really excellent independent reporter in the Southern District of New York, and he covers New York cases. His name is Matthew Russell Lee. He goes by Inner City Press. He'll actually file pro se against these judges. Like he did this recently where he was covering a case with Live Nation. They were in court for a monopoly, basically. The government was alleging that they were a monopoly, Live Nation and Ticketmaster, and Matthew Russell Lee followed this case. It's actually interesting. He reminds me a lot of David from Making Law Simple. Like, they could be cousins, I swear. in a good way. I love Matthew Russell Lee. I tag his channel in every single one of my description boxes. He was like basically like the reason I was able to do the Diddy trial coverage. He goes in the federal court and he live tweets, and he has permission to do that as an independent journalist. But sometimes, yeah, he'll sue. He'll basically sue. And it'll be like the government and the defendants all on one side trying to keep something secret. But he's like, no, yeah, no, you can't keep that secret. So he'll sue them. And the remedy is usually just like, okay, the judge orders it to be unsealed. So it's not usually going to be like, oh, the cops are going to jail, which, like, I mean, it sucks that they never really get in like real trouble. But anyway, thank you for that, $4.99. Okay. All right. So without further ado, let's just start with the new filings in the federal case. So I'll go on Pacer, and I'm just going to search by party. BAM franchising. Okay, so I'm going to go to this case here that hit the docket yesterday officially, to 2026 CV 00593. Oops, I clicked the wrong thing. So there's many, ways to navigate the Pacer site. The way that I do it is when I'm just trying to find documents, I go to the docket report, and I don't do any specific. I leave it in the default setting, oldest date first. I don't do anything. I just go run report. And there were some updates from yesterday that we talked about during the live. So there was this assignment to a magistrate judge. There was, so the cause here is notice of removal, personal injury, diversity jurisdiction, jury demanded. So the defendant, which is Ben, Victor, and Reckless Ben LLC, with the consent of Brian Mansell, are demanding a jury trial. So they're not going to just want to be sitting here and letting this judge decide it. No, they want a jury. If it ever makes it to trial. Now, there's been a lot of talk about settlement. There has been, you're like, yes, you are like everyone cool. That is indeed and in fact the truth. So what was I looking at? Okay, so a lot of people have been talking about how Ben will never settle. They're not going to settle. Ben will never settle. There's another way out of this lawsuit. Okay. And I mean, it is obvious, but at the risk of stating the obvious, another way out of this lawsuit is not a settlement, but instead a voluntary dismissal. Now, BAM at any moment, at any time, could have their lawyer march over there to the courthouse or march into the online portal and file a notice of voluntary dismissal. They could say, you know what, we withdraw. We don't want to sue them anymore. Bye. And they could move on with their life. So this lawsuit could end before it goes to trial without Ben having to settle. There's been a lot of talk about settlement, and most cases do end in settlement. Most cases never make it to trial. That's a crazy statistic too. It's like 98% or something, maybe higher than that. So most cases never do make it to trial. This would be an anomaly if it did make it to trial. I don't know what Ben is going to try to do. There was some mention of him believing his rights were violated under the anti-SLAPP laws of Utah. And so we don't really know what Ben is going to do. We don't really know what he's going to fire back with, but he has demanded a jury trial, which is his right. Okay, so we do have actually a brand new filing even since I've been on here. So yesterday, the last time we checked this docket, there were only 4 entries in the docket, and some of them didn't have corresponding actual documents. We did take a look at the notice of removal. A couple days ago, we looked at the notice of consent, which was filed by Brian Mansell. We looked at this this notice from the clerk's office that was saying that this Mina Gorianna was not able to practice here. She was representing BAM Franchising, Baker Bricks, Brandon Best. Ugh, it's so hard to say. BAM Franchising, Baker Bricks, Brandon Best, Joshua Johnson, Amy McNeff, Matthew McNeff, but she wasn't admitted. So we talked about that. I kind of said that's not really that big of a deal. She just probably has to file a little bit of paperwork. Then this magistrate judge was added as well. I did discuss how sometimes in, some jurisdictions, magistrate judges kind of don't handle full on trials. Maybe they'll handle things that happened before. They'll handle preliminary issues, motions in limine, et cetera, et cetera. But then I did kind of walk that back because I don't know how it works in Utah. So, really, I don't exactly know the difference between a magistrate and a regular, full judge. I do think I didn't watch the video, so I can't like personally vouch, but someone did tell me that another lawyer YouTuber, barbecue, BBQ, some BBQ lawyer, BBQ brother, BBQ counselor, some y'all probably know who I'm talking about. Shout out to him. He apparently did make a video. Again, I didn't have time to watch it yet, but he made a video apparently discussing the differences between the magistrates and stuff. But there's been another document filed in that matter, in that along those lines as well. And then yesterday we also looked at this notice of availability of judicial settlement conference. So pretty much the District of Utah offers settlement conferences as an alternative before going or other than going to court. We talked about that. So yesterday, those were the major documents that were listed. Then after I got off the live stream, there were a few more things filed. These three, docket number 5, 6, and 7, notice from the clerk's office regarding attorney's status. This is about Attorney John C. Clark, defendant. He is appearing for Brian Mansell. Same issue as the other lawyer. He's not currently admitted, so he has to file for this pro hoc, ad hoc, vice, whatever it is. So then that one, that's John C. Clark on the behalf of Brian Mansell. Also, there's this document, which I do want to pull up, docket number 6. It was a notice of presiding magistrate judge assignment. This case is assigned to a magistrate judge. You're hereby notified that a magistrate judge for the District of Utah may conduct any or all proceedings in this case, including a jury or a bench trial, and entry of final judgment. Exercise of this jurisdiction by the magistrate judge is permitted only if all parties voluntarily sign and return this form. So we will take a look at the form. Then there was another docket entry, number 7, motion for admission pro hoc vice of Edward T. Decker. We'll take a look at that. That's docket number 7. And then I guess this morning, a similar document was filed by another lawyer, John C. Clark. Okay, so Edward Decker, John Clark, they're filing ad hoc, no, this one, pro hoc vice motions. So I'm going to download that document because I had not previously seen it and I don't already have it. So let me pay my $1. Let me pay my $1. I guess I should have gone to the court listener instead of paying this $1. Somebody probably already did this. It's docket number 8. Because if you go to it's 10 pages long. If you go to the court listener website, Pacer Monitor, I think, they have a lot of these for free. So I should check that first next time before I pay $1. Okay, this is 30. Docket number 8. Pro hoc vice John Clark. All right, so I want to take a look at those documents. And this is in the federal court, by the way. This is the federal docket. Okay, I'm going to pull up document number 6. That is that consent to the jurisdiction of a magistrate judge. We just read on the docket that the magistrate judge can preside over these hearings, but only if the parties consent. So this is that actual court filing, consent to jurisdiction of a magistrate judge. Do not electronically file the consent in this case. You are hereby notified that a magistrate judge for the District of Utah may conduct any or all proceedings in this case, including a jury or bench trial, including all the way up to the entry of a final judgment. Exercise of this jurisdiction by the magistrate judge is permitted only. Okay, so really this judge don't have jurisdiction. But if all of the parties consent, then it would be permitted, okay? An appeal from judgment entered by a magistrate judge will be made directly to the United States Court of Appeals for the 10th Circuit in the same manner as an appeal for any other judgment in this court. There are good reasons to consent to the jurisdiction of a magistrate judge. Magistrate judges have experience with nearly all types of civil matters, and their cases are usually resolved more quickly than cases before a district judge. A magistrate judge's trial dates are more certain because magistrate judges do not preside over felony criminal matters, which take priority over civil jury trials. So they're basically like saying, like, these are some of the reasons why you might want to say yes and let this go, to a magistrate, because otherwise you might be in court for a lot longer. The magistrate judges do have experience in nearly all type of civil matters. The clerk's office will send the consent form to the parties in two instances. The first instance is where cases are assigned to a magistrate judge at case opening. That's what happened here. Okay. The parties will have 21 days from the date the clerk's office sends this form to return it to the court. When a party is added later to a case, after the existing parties have consented, the consent clerk will send the consent form to the newly added party. The newly added party will have 21 days after the clerk sends the consent form to return it to the clerk's office. So each person or party that is that is added to this case is going to have to consent to the jurisdiction of a magistrate judge. I don't know if they will or won't. This isn't, again, something that I have a lot of knowledge about. The form will only be filed in the case if all the parties consent. The parties may return one form or they can return individual forms, whichever process is easiest. They can decline to consent, and there will not be any negative consequences. If any party does not consent, the clerk's office will not communicate a party's identity to any judge assigned to the case. If a party requests case reassignment, the clerk's office will not docket the form in the case. When a party fails to return the form, the case will either remain assigned or be reassigned to the district judge. Parties are reminded that each district judge may still refer matters to magistrate judges pursuant to the law. Okay, fine. This is what the consent form looks like. Do you consent? Yes or no? Yes or no? Okay. Anyway, that was one of the things filed. Like I said, it's not at this point, from what I understand, particularly substantive, but I did want to cover it. In any event, Making Law Simple said, if BAM does not consent, it would kind of be like a slap in the judge's face. I see. Okay. So what else? So there was this motion. I'll just show y'all this just so that you can, say you laid eyes on all these documents. This is docket number 7 in the federal court. So we're already up to 8 filings, or 8 docket entries, rather. This is motion for pro hoc vice admission, and this is filed by Mark O. Morris from the law firm Snell and Wilmer, LLP. He says, I move for the pro hoc vice admission of Edward T. Decker as counsel for defendant Brian Mansell. Okay, so Mark Morris moves to enter this lawyer, Edward Decker, Decker, as lawyer for Brian Mansell. I consent to serve as local counsel. So this guy, Mark Morris, is going to be the local counsel. I'm an active member of this court's bar. The application and proposed order are attached as exhibits, and the admission fee will be paid to the court at the time of filing. I certify that I have verified with the applicant that the information contained is true and accurate. Wow, he's admitted a lot of freaking places. golly. State of New York, State of Oregon, State of Washington, U.S. District Court Eastern District of New York, Southern District of New York, Eastern District of Michigan, District of Oregon, Western District of Washington, Eastern District of Washington. And he has never been the subject of a disciplinary action. Okay. So he signs there. He is in good standing with the state bar. So this is just a form that all attorneys have to do if they're not admitted to practice in a certain state. This is pretty customary, especially in federal court. And then we have a similar form being filled out as docket number 8. This hit the docket today. Again for Brian Mansell. I move for the Pro Hoc Vice admission of John C. Clark as counsel for Brian Mansell, and it's also submitted by Mark O. Morris. So Mark O. Morris did have these two people. He's going to be the local counsel. I know. I thought you were admitted to the Eastern District of Michigan. I remember you saying that. Thanks so much to Emblazoned Designs for the $2.50 pound, or the £2.50. Magistrate has prior defending corporate entities. Well, I mean, that could be a good thing too, because they know what's defensible and what isn't. Think of that $2.50. Yeah, that's a lawyer. Yeah, that's a lawyer. Yeah. I kind of like whenever a judge has at least some experience in business law if they're going to be adjudicating business matters, because at least it shows they kind of do know how things are at least supposed to go. Okay, so on top of that, there were also a couple new filings in the Tony Graff state case. So you know how this federal case, it was removed from the state court from Tony Graff, the guy who's overseeing the Charlie Kirk assassination hearing? Well, there was supposed to be court today. And obviously there's not going to be court today because it has now been removed to the federal court, at least for now. And we're going to see if the federal court is going to keep it over there, or if BAM Bricks and Minifigs is going to be able to argue somehow that it shouldn't be in federal court, which we've already talked about a few different ways they might possibly be able to try to do that. But there weren't really supposed to be any more new filings in this case. That's kind of like how it was postured. Like, there shall be no more filings, no more whatever in this case until or unless the federal court remands the case back down to the state level court. And it's unlikely that'll happen. But there were some new filings in the state level case. Nothing, again, too groundbreaking, but I wanted to show it to y'all just so that you can lay eyes on all of the different goings on. Pay him a little 20 cents to search here. This is where the case originated. Okay, so this is the filing right here. I have already purchased it. I'm going to pull it up, but this hit the docket yesterday. This is a request and order for electronic media coverage. This was filed originally. This is docket number 97 in the state level case. This was originally filed on the 25th. So it was originally filed the day before. Let me redact the phone number. A day before the notice of removal was filed. The notice of removal was filed by Ben on, no, it wasn't the AI guy. It was actually Court TV. So as you can see here, they say they wanted to live stream the court hearing. They also wanted to have newspaper, TV, video. And this was filed originally on June 25th. And so let me just make a little annotation here. June 26th is when notice of removal was filed. So it was filed when they thought there was still going to be court on June 30th before Judge Tony Graff. And the judge now has entered this order yesterday. Tony Graff entered, oh man, he needed a new pen. Look, he made a mess right there. He denied the request for the following reasons. He said, given the proceeding to remove the case, Jesus, look at this chicken scratch. Given the proceeding to remove the case to federal court, the hearing tomorrow is stayed and will not be held. He signed this yesterday, June 29th, 2026. So Court TV, Law and Crime, Court TV / Law and Crime wanted to stream the hearing. That was supposed to happen today at 1 o'clock. But the judge denied it because there ain't going to be no hearing. Okay, so Making Law Simple said, I filed one too, and they didn't even bother to respond. Oh my God, Noxicity. I thought the same thing. I was like, sure he's not a doctor? Oh my God, y'all are all saying it. I know we need a handwriting analysis, but to me, I think it's giving scattered mind. It's giving rushed. It's giving not paying attention to detail. It's giving not taking pride in one's public work. That's just what it looks like to me. It's giving frazzled. Yeah, I agree. No, you cannot see my ID. I totally agree. It's giving frazzled. No, you cannot see my ID. Said his writing looks anxious. That judge is stressed. Looks like it. Thanks so much, Voices in the Wall, for the $5 Canadian. Appreciate that, $5. Not bad enough for a doctor, somebody said. It's giving ADHD. He hasn't slept in days, so they need to file again. No, not necessarily, but not necessarily. But if there is going to be a hearing eventually, then they would need to again. Hold on, I gotta send a text. Okay. So what else do I have here? That was the main, other filing there. Again, not substantive, but it is nice to officially see from the judge himself, yeah, no, there ain't no court today. It stayed. We're not going to be having a hearing today. But he did say stayed. He didn't say canceled. So that just means he's holding a space open. I guess eventually in the future if it comes back down to him, but for now there's no hearing today. That's the main thing from that. All right, let's see. All right, let me go back to my notes. Okay. So, we know this is not the only case going on, although this is the case that recently has had the most activity. This is the civil case filed against Reckless Ben and Reckless Ben LLC rather, and again Ben Schneider, and against Victor Nguyen and Brian Mansell. And I think because of the media coverage and the YouTube and the this and the that, it kind of has now been put into this way of and also because of Bricks and Minifigs own statements that they make publicly, it seems like they are trying to act like Brian Mansell is not the person they have the biggest issue with, and it's actually Ben who they have the biggest issue with. However, legally, that's just actually not the case. Legally, they are accusing Brian Mansell of being the leader of the criminal enterprise. So and I do have the complaint, we'll pull it up, but it's not like they're saying the cops are saying that. The cops are saying that in American Fork. The cops are saying that Ben is the leader of some, criminal enterprise or whatever. But in the actual civil case where the RICO is actually being argued upon, they're saying Brian Mansell was somehow the ringleader. And this is just like really aggravating to me, frustrating to me, and logically inconsistent to me, because at the same time that they're saying Brian Mansell is the ringleader of this RICO, they gag Brian and his family and Ben and Victor and Reckless Ben LLC and all of that. And they basically get this kind of like indefinite temporary restraining order that is only supposed to have lasted 14 days. That thing is way, way longer now at this point than 14 days old. And they released that statement yesterday saying, oh, we are still dedicated to finding an amicable resolution, whatever it is, with Brian, with the Mansell family. Excuse me? Y'all are suing him saying he's leading a criminal enterprise. Civil RICO. They are accusing him of leading a criminal enterprise publicly. And in lawsuits to the public, in interviews, but then at the same time, they're saying, we're dedicated to an amicable solution. All the while, he can't even speak. They're putting out all their versions of the story. He can't even speak. So that is one of the things that I definitely wanted to get into today. But before that, we do have some new court audio. And that's not the court audio. Nope, that is an Edward Snowden post. Hold on. It's on Reddit, and thank you to the Redditor. Thank you to the Redditor who did post this. Who posted this last night, 12 hours ago. Awkward begets awkward. I'm just going to go. He said, I received some responses to additional audio requests from the court. The only two new things are his income was way too high for a public defender, and the prosecutor requests to put limits on his access to discovery. If you want him to stay out of jail, I'm just reading the Reddit post, okay? The Redditor says, awkward begets awkward said, if you want him to stay out of jail, listening to this will probably make you happy that he now has lawyers in all his cases. It doesn't appear that there has yet been a response from the prosecutor about discovery in this case. These are both for hearings in the American Fork case. That's Utah versus Reckless Ben, stalking and targeted residential picketing. The next hearing is August 12th. Okay, so let me pull up the case docket. This one is 261401094 in the courtroom of Thomas Lowe, BYU graduate. Stalking, targeted residential picketing. And these incidents supposedly happened on March 8th. So yesterday, the second waiver hearing was officially docketed for August 12th. I did discuss this yesterday. There was supposed to be a hearing tomorrow on this case. There was supposed to be a hearing, and it was indeed scheduled for July 1st, 2026, which is Wednesday this week. That's tomorrow. And there was a joint stipulation to continue the hearing. The reason being, or the cited reason being, that Ben's lawyer, Jeremy Delacino, and the co-counsel for Ben in this case are at trial this week. They're in a trial this week in St. George, Utah. Tufstino's like, I am so lost in this case. I'm gonna just be quiet and listen because I have no clue what's going on. It's a lot going on. That's my brother Tufstino. He's the one that has the this is his merch. But yeah, pretty much like if you don't know anything about anything going on in this case, pretty much like, there was this guy who passed over some Legos to this store, and he told the store, if you could sell them, you could keep some of the money, give me the rest of the money. regular consignment deal. The person he makes that deal with, you know, there's a lot of details I'm leaving out, but eventually doesn't own the store anymore. And there's lawsuits going on about that, by the way. And some new people come in. They supposedly are new owners, like completely separate from corporate, but come to find out they actually are connected to corporate. And they basically just like hostile take over this store. And, you know, the guy who has the Legos, like he has huge Lego collection. Like half the store or more of the inventory is his Legos. Or, you know, it actually technically was his dad's, but I'm just simplifying here. And so this guy whose Legos it is, he's like, all right, well, I mean, bet there's a new owner, but that's still my Legos. So give me my Legos back. And then the people that got the Legos in the store, these new owners who are actually affiliated with the corporate, they're like, oh yeah, we don't know what you're talking about. And they give all kind of different versions of the story. No, we don't have them. And then they say we do have them, but we shouldn't have to give them back. And then they say we might have some, but you know, you got to be able to prove to us which ones. And they just change their story, and lawsuits ensue. However, there's this YouTuber gets involved and he starts making expose videos on the situation, and he starts going around and trying to ask questions, trying to serve lawsuits, you know, calamity ensues. And then the police pretty much like take the side of these corporate people. And they eventually, that's how I end up getting involved in this case, because they eventually start like abusing this YouTuber and following him around, hunting him down like prey, and saying weird stuff like they do stuff differently in Utah. They pull him over for no reason. I'm leaving a lot of stuff out, but that's the long and short of the story. And so now there's four different lawsuits going on. Two of them are civil between the parties, and two of them are actually criminal. So the one we're looking at here has to do with supposed stalking. So yesterday we looked at and picketing, where he went and was, you know, doing a protest in somebody's neighborhood kind of thing. So we looked at this yesterday, but this has now hit the docket, and then the hearing is pushed off. Yeah, very wrong. And also, you'll be so proud of me. Look, I made my first Lego set. It's a some type of flying craft. It has the Mandalorian. He has a helmet. He has two pew pews and the tiniest baby Yoda Grogu in his little car seat right there. I don't know if y'all could see him. My camera is not on automatic what's it called? Like automatic autofocus. It's on manual focus, so I can't like, there went Hello Kitty. I can't like put it closer. It'll just be blurry for y'all, because I don't want that thing like bzz, bzz all day. But anyway, there's my little Grogu. That was my first Lego set. Also got another Lego set over there behind me on my shelf. Y'all been asking about the Hello Kitty. Where did I get the Hello Kitty? This is a gift from Japan. My friend Pamela brought me that. She's also the same one that made that bedazzled my microphone and my headphones. Okay. So anyway. So that hearing that was supposed to be on July 1st, supposed to be tomorrow, it's also now pushed off. So the next hearing that we do have this week is going to be July 6th. Is that this week? No, next week. It'll be next week. July 6th. I wouldn't be surprised to see that one pushed off as well. However, it was this case right here, State of Utah versus Ben, under the judge Thomas Lowe, that we got some audio. So 2 audio recordings have now been released, and this is from a public records type request that this Redditor made. And shout out to them and thank you to them for doing that. Awkward begets awkward. Posted it as the legal documents in the Reddit. I received some responses to additional audio requests from the court. And then he kind of summarizes the 2 new things. Also, if you are brand new and you are trying to get, you know, acquainted with the case and it feels like overwhelming, what I would strongly suggest you do, go to Reckless Ben YouTube page and just watch the 2 videos. One of them is like, I found the thief who stole $200,000 in Legos. Watch that one. And then a few videos forward, he makes another video, which is technically the part 2. And it's like, I got arrested for investigating Legos or something like that. If you watch those 2, that's like the 2 starting point, I would say. Okay, so the prosecutor requests, okay, if you want to stay, okay, these are both for hearings, American Fort case. The next hearing is on August 12th, which we did just take a look at here. Now, there was a hearing on WebEx that happened, initial appearance. So this is Ben's initial appearance. We're going to listen to the audio. On top of that, we are also going to listen to the continuance waiver hearing. Okay. The next hearing in this case, again, is not until August. So it's going to be like not next month, but the next month. So we're going to listen to the April 8th hearing first. And these are very short. Initial appearance. So first, let's listen to the initial appearance. I think the audio should work. Y'all let me know if you cannot hear it.
Our last 8:30.
Oh, sounds weird. Is there a volume button here? There's not. So I don't know how loud it's going to be in y'all's ear. Let's just listen to it straight from the website.
Benjamin Schneider. I don't know that he's here. I haven't seen his name.
Girl, it sounds like we underwater in here.
I'd just like to make sure he's not waiting. Okay, Mr. Schneider, are you there?
Yeah, I'm here.
Thank you. You've been charged.
Y'all can hear it. It's kind of loud. I apologize. I don't think there's any way for me to adjust the volume. See, there's no like volume. Y'all see a volume? Oh, here. Here we go. I'll turn it like to half the volume. Maybe it'll be a little bit quieter.
Stalking a Class A misdemeanor. Our last 8:30 is Benjamin Schneider. I don't know that he's here. I haven't seen his name, but
Did that make a difference?
I'd like to make sure he's not waiting. Okay, Mr. Schneider, are you there?
Yeah, I'm here.
Thank you. You've been charged with stalking, a Class A misdemeanor, and targeted residential picketing, a Class B misdemeanor. The Class A is up to a year in jail. The Class B is up to 6 months. You have the right to a lawyer, and if you can't afford one, we'll appoint one. What are your plans regarding an attorney?
I've called some lawyers, and they said just do this first court case and then meet with them after and see what you guys say here, I guess.
So one thing I'll say about Ben, I think he's very brilliant. I don't want anything about to say to be like taken as criticism at all whatsoever. There's just different like ways to say things in the law. Like one thing I noticed, and other law tubers have noticed, like he doesn't or hasn't in the past like really understood the difference between a civil cause of action and a crime. Like he'll be like, I'm being accused of civil crimes, and it's like, well, no, kinda, yeah, he is being accused of crimes in civil court, but just so y'all know, there's two different ways you can find yourself in court. One's criminal as a defendant. One's criminal. One's civil. Civil is a so-called private cause of action, a private right of action. It's where two private parties, i.e. not the government, not the state, are fighting in court. This would be like defamation. This would be like even battery, stuff like that. That can be civil. Harassment, stalking, stuff like that. That can be civil. So if someone sues you for harassment or stalking or digital doxing or sharing deep fake, you know what, or whatever, that's a civil. Now, it could turn criminal. It could turn criminal or not. It's up to the prosecutor to decide if that's in the budget, if that's something they want to do. There's always political, it's never just like, oh, did someone possibly do a crime? Let's prosecute them. No, it's all these different things. So RICO has a private right of action, a civil right or a civil cause of action. So yes, the government does charge people with RICO. It is like a federal statute. However, there are state RICO statutes as well, which allow, and the federal one too, which allow people to sue in a private right of action, private cause of action rather, for RICO. So that's an example. Another example here is I think what Ben is saying, and again, I've never talked to him. I don't really know, but I think what he's saying isn't that his lawyers told him to handle this whole case alone. I think what he's saying is I've talked to a few lawyers and they told me to just come to this hearing and see, in the initial appearance and then move forward from there. He does say case, handle this case and see. I really think he meant come to this hearing. I've talked to some lawyers. All of them told me just go to this hearing, this next hearing. This again was on April 8th, more than 2 months ago. So I think it's because the way he says it is like technically incorrect. It's not like, I don't know if it is or isn't, by the way. He might have really meant this, but I don't think so. I think what he meant was they told me to just come to this initial appearance hearing because nothing's going to happen today. And then, they'll end up coming through later, which is what ended up actually happening.
Forward and we'll appoint one. What are your plans regarding an attorney?
I've called some lawyers, and they said just do this first court case and then meet with them after and see what
Shout out to Sheldon. Shout out to Sheldon Norcross. Are you at 10,000 yet? We need to get Sheldon to 10,000 subscribers, by the way. Sheldon Norcross was unconstitutionally detained, in my opinion. He had his rights violated by the American Fork Police Department. He handled the situation very well. He handled the situation with a lot of discipline and self-control, because I would have been cussing them the up, down, up one side, down the other side, and all of that, which is not, don't act like me. Be like Sheldon, don't be like me. But yeah, so he's actually, like, aware of the story. He knows Ben. He has spoken to Ben. I don't think about this. Ben is obviously gagged. He's restrained from being able to speak about this, but he has a little more insight into the situation than I. And he said, yeah, that is what Ben meant. That, his lawyers told him, just come to this initial appearance and we'll be there later.
Do this first court case and then meet with them after and see what Gorianna.
All right, so you intend to try to hire your own?
Yes.
All right, your next court date with me will be on May 20th at 9:30 in the morning.
And we do have the audio for that hearing as well, which we will listen to after this.
That'll give you time to meet with an attorney, hire them, and make sure that you and he or she are with you on May 20th at 9:30, okay?
Okay.
Can I ask you how you got the link for today's hearing?
How did I get the link? Through,
Okay. All right, I just want to make sure we had your email address.
So the judge here who is asking these questions, this is Judge Thomas Lowe. He's on the thumbnail, but I'll pull up the picture. So sometimes for me, it's easier to... Oh, man. Why does this Thomas Lowe look just like Ammon? That's not him, though. It's this guy. This guy right here. That's Thomas Lowe. When was he sworn in? 2010. Okay, so he has actually been... Ew, that toe. He has actually been a judge for quite a long time. So, here's all the... Let's see if we recognize any of these guys. Just this one. This is the one that signed the unconstitutional search warrant. Stino, if you're still in here, that's the video you should go watch. After you watch Ben's videos, part 1 and 2, that's where you should definitely start. Jump immediately straight to the search warrant video that I made, because with this guy as the... You're going to be so mad at that search warrant. I mean, we all were over here. Okay, so that Thomas Lowe, the one with the, like, blonde hair, that's the one I just showed y'all. That's the one here. That's the one who's talking now here.
how did I get the link? Through,
Okay. All right, I just want to make sure we had your email address. My clerk just told me we do. So you're
This
good.
audio
Have a good day.
sucks.
Okay, thank you so much.
You're welcome.
Okay. And that's no shade to the person who uploaded or downloaded the audio. That's more like just, I think, these antiquated court systems. Okay, so they did make an AI generated transcript, and I'll read relevant parts. We just did hear it, but just, these hearings have been very short. All of the audio that we have heard so far from all of these hearings have all been short, just like that. You're facing up to a year in jail. And that's usually what a misdemeanor is. It's like the jail time you're facing is less than 1 year. And so for that reason, they're like, it's a misdemeanor. Sometimes it would have to be less than 6 months. You have the right to a lawyer. Oh, sorry, excuse me. The Class A misdemeanor is up to a year in jail. The Class B is up to 6 months. You have the right to a lawyer. If you can't afford one, we'll give you one. What are your plans? He said, I've called some lawyers. They said, just do this first. I think he meant hearing and then meet with them after. He's like, yeah, I'm going to hire a lawyer. So you intend to hire your own? Yes. So even as early as April 8th, while everybody's freaking out all the way in June, you need to hire a lawyer. He was going to hire a lawyer. Okay. He knew he needed to hire a lawyer. He's always been telling the judge, yeah, I'm going to get a lawyer. Okay. Next court date is going to be on May 20th. That was last month at 9:30. That'll give you time to meet with an attorney. How did you get the link for today's court hearing? Just want to make sure we had your email address. Okay, that's weird to me, because why wouldn't he have just said, do we have your email address? Like, how did you get the link? Like, what? Why didn't you just ask, do we have your email address? Anyway. Yeah, Utah court bought shitty aux cords from Temu. They probably don't even have aux cords. It's probably USB. Okay. All right. So now we're going to move on to the May 20th hearing. And just to remind you, what is that? That is the one we just heard was the initial appearance. Basically, hey, hi, you're Ben. Okay, great. Do we have your email? Yes, we do. Okay, great, cool. So May 20th, he had a continuance waiver hearing. And then on that day, it was amended. So we're going to listen to that now.
Bye. And Mr. Benjamin Schneider, if you could unmute and let me know that you're there. Benjamin
Hey, I'm here.
Okay,
So what I'm going to do, they did include, again, thank you so much to this Redditor, another shout out, awkward begets awkward, because not only did they post this for all of us to hear and see, they also did go the extra mile, did the AI generated transcript so we could read it as well, and went out of their way to actually request this in the first place. So shout out to this person. This is about a 9-minute 42-second long audio recording. What I'm going to do, I'm going to play it here, but then I'm going to switch over to the transcript so y'all can read along, and we can all read along with what is being said over here on the audio, because the audio is kind of compressed in a weird way and kind of distorted. I feel like I'm underwater or something, but this is what we have.
Mr. Benjamin Schneider, if you could unmute and let me know that you're there. Benjamin
Hey, I'm here.
Okay, thank you. I don't see you've hired an attorney either. Any
Excellent observation. Thank you, Zane. This is right before the video came out. That's so true. You're so right. This is before the video came out. The video came out the next day. The next day was May 21st. And not only did the video come out the next day, you know what else happened the next day? Legally Mine changed its name at 4:49 p.m. The same day the video came out. Yeah, that.
on that front?
So I have been looking for attorneys and calling them, and basically every single one has just recommended that I take on this case myself and don't hire them. They said it should be a pretty easy case for me to do. I think there's a lot of misunderstandings in there that I can clear up, so.
All right. Are you asking to represent yourself, or would you prefer that I see if you qualify for public defense?
So this is a change. He said on April 8th, I'm going to be getting a lawyer. And now he's like, well, no lawyer thinks I need to take this case, or they need to take this case. So the judge is like, so do you want to represent yourself?
Oh, no, I just want to represent myself.
You do have that right, and I won't deny it of you unless I find that there's a reason why you can't. Tell me what schooling you've completed.
So some of the lawyers I've talked to, they actually requested that I request a public defender just to get the footage of the body cams, because right now I kind of don't even know what I'm being charged for, because all of the body cam footage has been redacted, and they say it's to protect the victims. However, I think there are some redactions that maybe don't make sense and that weren't to protect the victims, and there's some things being said about me that are redacted that I don't know
Let me
about.
follow up on that, Mr. Schneider. Do you have any income currently?
Yes.
How much do you earn?
It varies month to month, but about $20K a month.
Wow.
Well, then you don't qualify.
$20,000 a month. Wow. So the judge is like, okay, well, you definitely don't qualify for a public defender. You can afford a lawyer.
Qualify for a public defender. Did you finish high school?
Yes.
Did you complete any college?
Yes.
Do you have any mental health diagnoses?
No.
Have you ever represented yourself previously in a criminal case?
This is my first time at court. I've never been in trouble before.
Have you ever represented yourself in a civil case?
I did one time, yes.
What kind of case?
But I was the plaintiff.
What was the case?
I was doing a documentary on this guy.
It's not included in the transcript. I guess it didn't pick it up. Ben said, I did one time, yes, but I was the plaintiff. So he was the one suing instead of the one being sued in that civil case. The judge said, have you ever represented yourself previously in a criminal case? He said, no, I've never been in a criminal case. This is my first time. Okay, what about a civil case? He said, yeah, I did one time, but I was the plaintiff, not the defendant. The judge said, what kind of case was it? What was the case? Listen what Ben says.
And so I sued him and won.
All right. Was it a small claims case, civil case?
I did one time, yes.
What kind of case?
I was the plaintiff.
What was the case?
I was doing a documentary on this guy who was torturing people, and so I sued him and won.
All right. Was it a small claims case then?
Yes.
All right. Small claims cases, there's very relaxed rules of procedure. Here in district court, the rules are tighter, stiffer, more or less lenient, I guess, more strict. So I just need to let you know that you'll be required to abide by the same rules and statutes as a lawyer would, and you might be at a disadvantage because you don't know what those rules and statutes say unless you do some really good research. Do you understand that disadvantage inherent in representing oneself?
Yes, sorry, the Wi-Fi cut out for a couple seconds. Can you repeat what the disadvantage is?
Just that you may not know the rules that are applicable to your case, but you'll be responsible for knowing them even if you don't, meaning I can't excuse your non-compliance just because you don't know what the rules are. Do you understand that?
Yes.
Also, any statements you make in court are...
This is a big one. Okay, so just so y'all know, this judge isn't like going out of his way to pick on Ben. This is actually really good that he is telling Ben this because a lot of times people representing themselves don't realize not only the obvious disadvantages that you are put at when you represent yourself. You know, obviously there's some that are really obvious, like, okay, well, you still are going to have to be held to the same standards of court decorum and filings and stuff. Well, yeah, duh. But also everything you say in court can still be used against you. So even if you're representing yourself, the other side can use those statements that you make against you. Whereas if you have a lawyer, the other side cannot use your lawyer's statements in the same way as if it is a statement you made. So the judge is letting him know, and I think this is even a statutory requirement, that before a judge allows a plaintiff, a defendant in a criminal case to represent or defend themselves as their own lawyer kind of thing, even, you know, especially when they're not a lawyer. They have to read this stuff so that they understand their rights and their and the expectations that are going to be put on them.
Can't excuse your non-compliance just because you don't know what the rules are. Do you understand that?
Yes.
Also, any statements you make in court are recorded and could become evidence to be used against you later on. An attorney's statement on your behalf isn't any sort of evidence that could be used against you. But anything you say could later on be used against you. Do you understand your right to remain silent and the necessary waiver of that right should you represent yourself in this case?
Yes.
All right, you still want to represent yourself?
Yes.
The court will allow it. We'll set this matter over to July 1st at 8:30 in the morning. We'll put you on the earlier morning calendar and give you time to request discovery. And before I move on, though, Mr. Farr, I do see...
Okay, now we're about to get into some drama here, okay? Because these freaking imbeciles, I will say, they want to prosecute Ben, but they don't want the public to see what they're doing. Let me show you what I mean.
Do you see a proposed protective order in the file? Did you want that signed?
Yes, Your Honor, and then I do have...
The person talking is the prosecutor, the person that's trying to put Ben in jail for at least a year and a half or whatever.
some concerns in this case with the defendant representing himself. The allegations here relate to the fact that the defendant, he's a person he's a YouTuber, creates videos, publishes them online, and has been we have an alleged victim here, JJ. There's been attempts to communicate with him. There's been attempts to go to his home. I think there's attempts to film him.
To communicate with him and to go to his home to serve him with legal process and to film him while he's out in public screaming and ranting and huffing and puffing. But of course the prosecutor is also, just like the American Fork Police Department, trying to cover for Josh's actions and trying to basically make it look like something happened that did not happen in front of the judge. But he doesn't just stop there. He gets more corrupt, this prosecutor.
There's some, the allegations are some harassment of this person at his home. if this defendant were
By
to
the way, he's not charged with harassment. They're not charging him with harassment. They're charging him with stalking residential picketing. So if it's harassment, then they should have charged him with that. But here is this prosecutor using an allegation of a crime that he didn't even have enough evidence to charge Ben with, but he is using this potential harassment, even though he didn't charge him for harassment, as a reason to violate Ben's rights.
were to represent himself and we were to provide body cams and discovery, we would be now providing additional information and fodder for this defendant to create videos from which he could profit by placing them on YouTube.
Yes, that is how public records work, you uninitiated novice.
YouTube at the expense of our victim. I have serious concerns for this person's rights.
He has serious concerns for Joshua Aaron Johnson's rights, even though he lied to police, but he doesn't obviously have serious concerns for Ben's rights to represent himself. Isn't that interesting?
And so, what we have here as a defendant lives out of state, and I don't know how well we're going to be able to assert jurisdictional authority over him if he were to violate any of the court's orders on disseminating further the discovery.
Disseminating further the discovery. You just heard Ben say earlier in this case, I don't even know what I'm being charged with. I don't even know what they're charging me for because I have some body cam, but they have it so redacted. I don't even know what I supposedly did. So yeah, I want to represent myself, and I need the discovery. And here's the prosecutor. No, we should violate his right to represent himself because we don't want the internet to know what we're doing and how court is going over here, even though it's a public record. Making Law Simple said, I want to ask this prosecutor what he thinks about the police accidentally releasing their own unredacted videos. Right. Because what we're listening to is from one day before part 1 came out. So this is before even stuff hit the fan. This is a day before their whole entire earth would begin to shatter. And so I also, too, wonder how this prosecutor now feels about the fact that the police put out their own. The police, he was so worried about the victim, alleged victim, Joshua Johnson. Are they going to go after the police for releasing Joshua Johnson's private information out to the world? They only want to go after Ben. Okay, got it.
I mean, I'm happy for us to provide the written discovery with the redactions of the victim's addresses. But as far as body cams,
the victim's address is a public record, and the victim himself made that a public record by putting the address in public documents, by the way.
I would prefer that the court allow us to state that our records are open. He can come and he can arrange for a time to go to the police station or somewhere else to watch those videos to gain the information that is necessary, but that he would not be given a copy.
Let me tell you something, Prosecutor Farr. What's done in the darkness surely and always shall come to the light. Okay, you're not going to be able to do hush hush, shush shush, taking away people's rights, putting them in jail. No, you're not. Without us seeing it. No, absolutely not. Oh, we'll let him come and look at the body cam at our office. What? Drop the charges then, Cub.
Not be given a copy of them because of the potential that those would be used to further harass our victim. This is a stalking case.
Mr. Farr, do you mind if I just interrupt? We're so far behind. There's not even a request for discovery filed yet. Would you mind addressing that after a request is filed?
Understood.
Way to tell us what you're really worried about, buddy.
Understood.
The judge.
Yes.
Okay, thank you.
The judge's like, he didn't even ask for discovery yet. So, no. What are you talking about? Shut up.
Today we're just going to allow Mr. Snyder to represent himself. Now, Mr. Snyder, you may file a request for discovery. The court's inclined to sign this pretrial protective order unless you have an objection.
So now they get to the third issue of this hearing. The first issue is he going to get his own lawyer. The second issue is this discovery stuff. Like, are they going to actually allow Ben to get the discovery materials? The judge is like, I don't even know what he even is asking for yet. So how about let's do that first? Oh, yeah. Okay, fine. The third issue is this protective order, which I do think is an unconstitutional infringement upon Ben's rights. And now there are 2 protective orders in place, and this is completely different from the temporary restraining order. There's a temporary restraining order from Judge Graff in the civil case, but there's also these two criminal protective orders against Ben from Joshua Aaron Johnson. And so Joshua Aaron Johnson has filed to get these, these criminal protective orders, and it is pretty serious. You're not allowed to be around the person. And again, there's litigation that Ben needs to serve papers for. And to interfere with his ability to do that, or to have the papers served upon Joshua Aaron Johnson, is, in my opinion, unconstitutional. At least it implicates constitutional rights. And now the judge is like, well, I'm gonna put this criminal restraining order in place, this protective order in place, unless you can give me a good reason why not. And Ben's like, yeah, there is a good reason. It's a violation of my rights and I didn't do anything to deserve it. And it's just infuriating. That's why I put the devil horns on the judge. In the thumbnail, you're about to hear why.
Unless you have an objection to it, Mr. Snyder, and it's supportable.
He's like, well, I'm gonna put a criminal restraining order in place. I'm gonna put a criminal protective order in place against you and make it look like you're a criminal already, even though we haven't gone to court over this, even though none of us have even seen any evidence, even though you don't even know why you're being prosecuted. I'm gonna put this criminal protective order in place unless you have an objection. Ben's like, yeah, I do have an objection, sir.
Request for discovery filed yet. Would you mind addressing that after a request is filed?
Understood. Yes.
Okay, thank you. For today, we're just going to allow Mr. Snyder to represent himself. Now, Mr. Snyder, you may file a request for discovery. The court's inclined to sign this pretrial protective order unless you have an objection to it, Mr. Snyder, and it's supportable. It would require you to have no contact with Joshua Johnson. Any objections to such an order?
Yes, I think there's a bunch of misunderstandings in this case. I think there have been lots of, basically,
lies.
The prosecutor's correct when he says that I'm a YouTuber, I make documentaries on YouTube. I basically look at cases of people doing really bad things, and I basically expose them. And so this person doesn't want to get exposed, so he's making up a lot of lies about me in order to get me arrested before he gets exposed. So that's what this whole—
You can hear the judge taking a breath to interrupt already. You heard him take that big breath in, like he wants to interrupt Ben so bad.
So that's what this whole thing's about. And so I think there's a lot of lies that made that protective order happen. So I would like to object and clarify everything.
Yep.
Okay, so you think it shouldn't be entered because you're innocent. Really what the court's looking at is to see if there's any need that you may have to have contact with Mr. Johnson, any prejudice.
So the judge is saying there is a presumption you are a criminal. Even though we have the presumption of innocent until proven guilty in the United States of America, even though the judge has seen absolutely no evidence at all whatsoever to indicate, again, the video, part 1 video has not even come out yet. The video has not even come out yet at the time of this recording. The video came out on May 21st. This hearing was May 20th. So the day after this hearing, that's when the video came out. So there wasn't even a video yet. The judge had seen absolutely no evidence. There hadn't even been a request for discovery filed. The only thing the judge had seen were statements from possibly the so-called alleged victim, Joshua Aaron Johnson, who, might I remind you, threatened to shoot the next person who showed up at his house, by the way. He also told police officers in American Fork on his front porch nobody had threatened him. The cop said explicitly, has anyone threatened you or your family? Josh said no. Okay, so there really is absolutely no evidence against Ben, and a criminal protective order which would infringe upon his rights, or at the very least implicate his constitutional rights, is something that he should be able to object to. But the judge is saying, no, there's a presumption you did it. There's a presumption you are a criminal stalker. So your defense is basically you're innocent. Well, we're not going to know. You're going to have to prove yourself innocent. We're not going to wait for the prosecutor to prove that you're guilty. No. We are going to have to presume you are a criminal stalker. And I don't know if this is the BYU treatment. I really don't know. If the judges that went to BYU and have, Mormons in their courtrooms, they're necessarily going to presume the Mormons are telling the truth. I don't know. I can only speculate because this is not how the justice system is supposed to work. Temporary restraining orders are one thing. This is a criminal protective order. The judge is already fielding questions about not even giving Ben all the evidence, which would be Brady material, by the way. And yes, Brady material still counts anytime jail is on the table, which this is a year and a half he could be facing. But the judge is like, no, we're going to just assume you are definitely guilty. So if your reason for objecting is that you're innocent, that's not going to cut it for us. No, you're already guilty is what this judge is doing. That's what put horns on him in the thumbnail.
This person doesn't want to get exposed, so he's making up a lot of lies about me to order to like get me arrested before he gets exposed. So that's what this whole thing's about. And so I think there's a lot of lies that made that protective order happen. So I would like to object and clarify everything.
Okay, so you think it shouldn't be...
So Ben said the only reason that protective order happened is because they lying, Your Honor. They lying. I don't even know why I'm being charged. Listen to the judge.
To order to like get me arrested before he gets exposed. So that's what this whole thing's about. And so I think there's a lot of lies that made that protective order happen. So I would like to object and clarify everything.
Okay, so you think it shouldn't be entered because you're innocent. Really what the court's looking at is to see if there's any need that you may have to have contact with Mr. Johnson, any prejudice that would occur to you if the court signed it.
Yes.
What's your prejudice?
That I've done nothing to warrant it being signed.
The prejudice is that you're limiting his constitutional rights to go where he wants to go, serve papers if need be, appear in court with Joshua Johnson. It could prejudice him in other litigation, which is ongoing and which is reasonably anticipated. There's a lot of prejudice that could be effectuated here. And Ben does give another good reason, which is, I didn't do anything. There's no evidence, and it would be restrictive of my rights.
All right, thank you. Mr. Farr, I guess the concern for you is this is a pretrial protective order under the Domestic Violence Act, and this is not a domestic violence case. Do you have a legal basis for its entry?
This is a filing for a protective order under the Domestic Violence Act. This protective order was filed under the Domestic Violence Act. This is meant for domestic partners. Obviously, Ben and Joshua Johnson have never lived together in a domestic situation, but they're going to, I think, really pull and push and strain this statute, which is in no way meant to apply to a YouTuber doing a story, whether he's a muckraker, whether he's a journalist, whether he's just a guy on the internet doing his opinion. The First Amendment right to talk about something of public concern applies equally to all those people, by the way. This statute don't even apply. And I would like MLS actually to look into this. Maybe he can look more closely into this too. But it's like they applied for this protective order under the Domestic Violence Protection Act, and they've never been domestic partners. This wasn't meant to apply to YouTubers or journalists.
Occur to you if the court signed it?
Yes.
What's your prejudice?
That I've done nothing to warrant it being signed.
All right, thank you. Mr. Farr, I guess the concern for you is this is a pretrial protective order under the Domestic Violence Act, and this is not a domestic violence case. Do you have a legal basis for its entry?
I think that pretrial protective orders are also allowable under 78B. Let me pull the statute. 78B. 78B protective orders, Chapter 7. Criminal Protective Orders, Part 8, Pretrial Protective Order.
Take the rights away now, figure out which statute applies later. Huh?
Qualifying offense under,
If you're just reading Article 3, then yeah, the qualifying offenses are domestic violence offenses, aren't they?
I thought that, Your Honor, I'll have to go look this up, but I believe that these are available.
Put it 2 in the chat if he should have looked this up before he came to court trying to restrict somebody's rights. Put it 2 in the chat if he should have looked this up before court.
Sex offense cases all the time. Any case where we have a victim who is being...
I just thought, never mind. It includes stalking.
Oh, good. So the judge and the prosecutor are working together right there in front of Ben to violate his rights. The judge, never mind, fellow BYU grad. Never mind, fellow Mormon. I found it. I gotcha. No problem. Now, was the judge working that hard to help Ben? To have his rights respected? No, he was only working that hard against Ben.
Yes.
So there's a statutory basis for it. Mr. Schneider, the court's going to sign this order and serve it upon you
I hope you get sued.
and require that you comply with it in the meantime. The address I have for you is in Los Angeles. Is that a correct address?
Yes.
All right. If you see a deputy come to your porch just to give you a copy of that order, they're not there to arrest.
So the deputies can show up with guns and bulletproof vests on Ben's porch just to hand him a piece of paper. But Ben isn't allowed to serve anybody a lawsuit. He isn't even allowed to send somebody to serve a lawsuit. There's 2 criminal protective orders, an unconstitutional restraining order, a $300,000 civil RICO filed against him, and he's going to have to get harassed by the police banging on his door to just drop off some papers. Don't y'all have his email address? It's just one abuse and one intimidation after the next. It's just, I just keep hearing those cops giggling and snickering off to the side. So what do we just want to scare him? Why do we need cops with bulletproof vests and weapons, guns, tasers, pepper sprays to show up to drop off some papers? Huh? Y'all don't have his email address? Didn't you ask for his email address earlier? Make sure y'all had it and all that. Now we got to have cops banging on the door? I wouldn't feel safe at my own home. Now you're going to get my cops in my jurisdiction to come to my door? Fuck you. Fuck all these people.
There's a statutory basis for it. Mr. Schneider, the court's going to sign this order and serve it upon you
Fuck you.
and require that you
Hope you
comply
get
with it in the
hemorrhoids.
meantime. The address I have for you is in Los Angeles. Is that a correct address?
Yes.
All right. If you see a deputy come to your porch just to give you a copy of that order, they're not there to arrest you, at least not from me anyway. Just to give you
That seems like stalking to me. It's only stalking if you're trying to get justice. It's not stalking if the government is abusing you. Got it.
a copy of this order. If you violate this order,
Fuck you.
not only will new charges be filed, but there's a possibility that you'd be held in the county jail without possibility of bail because you've demonstrated you can't follow pretrial orders. So make sure you read it, comply with it, have no contact with Mr. Johnson, and your next hearing will be on, like I've indicated, July 1st at 8:30. That give you time to file your request for discovery with the state, for the state to file any opposition they may have. You've already
This entire uphill battle, by the way, they already are bitching and moaning about having to give him Brady material, stuff that they literally have to give him. Oh, we don't want him to be able to practice and exercise his right to represent himself, Your Honor, because he's going to tell YouTube about it. Oh, yes, he is. Yup. And we're going to be sitting here lapping it up. Hope he gets 10 million views, part 3.
given a preview that they may object to you having physical copies of body cam or other videos, if that's what you're going to be seeking. But we can address those issues at a later date if you'd like. Okay?
Oh, yeah.
See you July 1st at 8:30. Have a good day.
Okay, thank you.
You're welcome.
Benjamin Paul Schneider, I will say, is so much more in control of his thoughts, emotions, and reactions than I am. I will say that. Thank you to Tim Cooper. Thank you so much for the 1999 super chat. Can I send? Yeah, I'll send you this link. Hold on. Let me send Making Law Simple this email or this these links. What is this? Oh. Okay, my payment went through for my records request. Update. This is for Utah versus Ben. Okay, let me just send this. All right, sent. Okay. Just reading some of y'all's comments. Okay. So that's the court audio. Pretty much said what, I needed to say during that. It does seem as though the judge was not interested in any way, shape, or form in actually respecting Ben's rights. He did do a little bit of that song and dance about trying to act like, oh, well, you know, if you represent yourself, I'm going to hold you to the same standards as everybody else, and you're going to have to be held to the standard as if you were a lawyer, and all that, you know, all the big scary warnings, but didn't really seem very interested in truly respecting the Constitution or Ben's rights. Seemed more like he wanted to help his BYU classmate out. That's what it seemed like to me. Okay, so speaking of people who, or sources who try to pretend to be an authority on something, but actually you can't trust a damn word they say, I want to move on to the next topic in today's investigation. And this is a Jesse Weber. Let's see, I have it on reader view, but I just want to show y'all just how much we just can't. I mean, we can't trust judges. We can't trust cops. We can't trust the news because they just don't say the truth. So lawsuit, look, what the hell is this News Nation article? That's what I want to know. The title is Lawsuit Against YouTuber in Viral Lego Case Set to be Dropped. So I see this article title this morning and I'm like, whoa, I missed something. Whoa, the lawsuit's going to be dropped? News Nation. This is an article from 2 days ago. The lawsuit against the YouTuber at the center of a series covering a missing Lego collection that went viral may soon be removed. Okay, the lawsuit may be removed. Removed to what? Federal court. That's the title says dropped. This is so confusing, and I do wonder if it's intentional or if they just don't bother to like actually look up what in the hell's going on. It's like they're confusing two things. There's a TRO, which may be dropped, and then there's the notice of removal to federal court. Neither one of these things is dropping the lawsuit, by the way. Bricks and Minifigs has agreed to drop its case. This is the news, newsnationnow.com. We just talked yesterday about how the Wall Street Journal had all kinds of misleading and inaccurate statements in their reporting on the matter. The lawsuit against YouTuber and viral Lego case set to be dropped? Lawsuit set to be dropped? Huh? That's not true. The lawsuit against YouTuber at the center of a series covering a missing Lego collection that went viral may soon be removed. Okay, so dropped and removed are two different words, by the way. Very different. Bricks and Minifigs has agreed to drop its case against Ben in favor of private mediation. This is not true. This is just straight up as not true. They did not agree to drop their case against Ben in favor of mediation. They did agree to try mediation. They said they were going to try mediation. Now, are they in the middle of it? I don't know. They most certainly didn't agree to drop the case. They agreed to modify the temporary restraining order, but none of those things are dropping a lawsuit. It's like, I don't want to just like have tinfoil hat, syndrome where like every single thing where the news is wrong, I'm like, they're lying on purpose to try to confuse and trick people. I really don't want to be that type of person, but I'm turning into that type of person because this is a professional news organization. Why are they not fact checking this stuff? I mean, I'm not a professional news organization. I'm not even a journalist. I'm a girl on the internet reading public stuff. I'm not trying to be, breaking. I'm the only one that knows this. No, everything I do and say is all from public stuff. A notice of dismissal was filed Friday. No, it the fuck was not. No, it was not. There's like a false statement in every single sentence we've read so far. Let's count them. Lawsuit case set to be dropped. Nope. Lawsuit may soon be removed. Okay. Yeah, but like you left out to federal court, but fine. Bricks and Minifigs has agreed to drop its case. False. A notice of dismissal was filed Friday. False. What was filed? Not a notice of dismissal. What was filed was Ben filing a notice of removal to federal court. It's just moving. It's not being dropped. If approved by the judge, Schneider would be free to speak publicly about the case again and release the third and final installment of his missing Lego collection series. No. See what I mean when I say I think that they're confusing the TRO stipulation and the notice of removal? And it's like, it's literally 2 documents. It really would have taken like almost no effort and maybe less than $5 for this professional news organization to actually figure out what in the hell they're talking about before they run a news story. But it's almost like, wouldn't it be nice to get some public heat off of Bricks and Minifigs if everybody thought that lawsuit was just done and over? Oh yeah, they're going to drop it. They're going to private mediation. This article might have came from an alternate dimension. It must be. We must be peering through the portal into a different universe where this happened. Schneider still faces misdemeanor criminal charges related to an attempt to serve legal papers on a Bricks and Minifigs executive in Utah. Those charges include stalking, targeted residential picketing, disorderly conduct, and trespassing. The situation began in November 2023 when Brian Mansell entered into a consignment agreement with Bricks and Minifigs franchise in Salem, Oregon. The deal was to sell his family's Lego collection, reportedly worth $200,000. The agreement was that the store would sell as much as it could, split the proceeds with Mansell, and return any unsold inventory to him. When he returned in early 2024, he learned the store was under new ownership and the new owners knew nothing of the agreement and didn't have the collection in their inventory. We'll see if that turned out to be true. That's when Mansell reached out to Ben, who began creating videos about Mansell's situation, accusing the franchise of theft. The story went viral. Ben was arrested twice, attempting to serve legal papers on a franchise executive, Joshua Aaron Johnson, at his home in American Fork, Utah. Ben Schneider posted multiple videos on his YouTube channel about the incident, including footage from police body cameras. Shortly after, Bricks and Minifigs filed a lawsuit against Ben Schneider, claiming he created the online content to harass and injure. The executives filed separate charges. Bricks and Minifigs claimed in a June 4th blog post that the franchise was not to blame for the missing collection. It accused the previous owner of making the agreement under the table. It also claimed to have evidence that the previous owners had 3 sets of books regarding the Lego collection with all different accounts of what was sold. It's interesting to me, News Nation, which I think is affiliated with Law and Crime and Court TV, who was trying to be streaming this hearing today, by the way. They didn't say anything about the police corruption. They didn't say anything about the unconstitutional search warrant. They didn't say anything about the repeated contradictory statements by these people. It basically is like, yeah, reckless Ben being reckless, but maybe they'll drop the lawsuit against him, but he's still going to be facing criminal charges. It's like, what is going on with these news articles? Like, why can't we get a single news article to just say things kind of like accurately? I mean, I am biased in this case. I really am. But I haven't been so biased that I don't see where, some criticism can be going to Ben, where maybe the judge or the cops did 1, 2 things right here, there. Why can't the news get this right? Okay, now I don't know if I could trust a single word comes out of anything over there at News Nation. Which brings me back around to one thing that I, didn't have a chance to mention yesterday. And it is still along these same lines of like, why can't the news bother to get stuff right? This is the Wall Street Journal article. Let me find the part where, and we did talk about this part, but it was, right here. This kind of came to my attention yesterday because I was watching Making Law Simple and Valhalla Awaits talk about this. Let's start here. Over 4 days in March, Schneider and his collaborators showed up multiple times at the home of the franchisee. The owner, Joshua Aaron Johnson, whose name they don't mention, called the American Fork Police Department and told the dispatcher he was going to shoot somebody, by the way, and at one point told dispatchers he was going to shoot someone. Police warned Ben and the others not to trespass on the property. Ben responded with more antics. Okay, so over the course of the 4 days, what was the first incident? Now we've watched it. What was the first point of contact, and what did Josh complain of? He called Tonga, and he told Tonga they had dropped off some duckies. Right? That was their first thing. Schneider responded with more antics, filming all the while, just like the cops were, by the way. The cops were filming all the while. Josh Johnson had a Ring camera that was filming. He had his phone filming. So the cops were filming, Joshua Aaron Johnson was filming, and Ben was filming. All three were filming, but only Ben gets held responsible for filming all the while. Okay, interesting. He and his team used ruses. Okay, he responded with more antics after what? Being warned not to trespass. That's not true. The fake UPS outfit happened before. The fake UPS outfit happened before he was trespassed. Police warned him not to trespass after, because the first point of contact with the cops from Joshua was they tried to drop off duckies at my house. So the fake UPS thing had already happened. So wrong that he responded with more antics, because this fake UPS cap happened before he was trespassed. They're making it seem like he kept doing this. They're making it seem like Ben was the one wearing the fake UPS cap. I mean, they do say and his team. But this right here is where really, I mean, this is going to be nerd. This is going to be nerd level grammar, okay? But the reason that I feel confident and comfortable to discuss it and to mention it here is because we are talking about the Wall Street Journal. We are talking about the Wall Street Journal. These people who write these articles actually know English grammar, and they're supposed to know how to write. Put a 3 in the chat if you're familiar with the Oxford comma. Put a 3 in the chat if you ever heard of the Oxford comma. Put a 3 in the chat if you are familiar with the so-called Oxford comma. Okay? I'm about to flex my English degree on y'all. All right? Put it to use, I should say. Oxford comma. Let me show y'all what it is very quickly. This is when you're making a list, a series. You're listing a series of things in your essay and your writings. The Oxford comma, also known as the serial comma. They also call it the Harvard. I never heard it called the Harvard comma. I've heard it called the serial comma and the Oxford comma. Is the optional comma placed before the conjunction and or in a list of 3 or more items. So you have an example right here, the Oxford comma. I want to have, what do you want from the grocery store? Milk, bread, and eggs. Okay? Milk, bread, and eggs. Now, they call this Oxford comma optional. However, this is coming from my English degree that I earned. I used to love grammar. I used to be on the grammar. Okay? The time when a serial comma is not optional is whenever it's used to avoid ambiguity. All right. What is ambiguity? Ambiguity is where something could be read one way or another way. And so you put this comma there to make it obvious what you mean. All right. Again, the Wall Street mother freaking journal of all these people would know, and their writers would know about Oxford commas. Okay. So let me pull that back up. I agree with you completely, MLS. I'm just saying, he said it is never optional. A lot of lawyers, including me, do not think it is optional ever. I agree. I like to use the Oxford comma unless I'm running out of characters on my tweet or whatever. Valhalla said this, that, and those. Yes, that is an example of the Oxford comma in use. Okay. Now, if it's casual writing, you don't have to put it. However, and this is what I was trying to like scream into the chat yesterday on MLS and Valhalla's stream, but I'm like, okay, I'm just pointing out here. Schneider responded with more antics, which we already established is misleading at best, right? Because he did not respond to being trespassed with more antics, including a fake UPS cap. No. This already happened first. Actually, the response, if anything, was being trespassed in response to the fake UPS cap. Okay, so we already established that. But then it goes on. Schneider responded with more antics, filming all the while. He and his team used ruses to try to talk to Joshua Aaron Johnson or serve legal papers, including appearing in a fake UPS cap, fake. I mean, this is totally false. Posing as a Mormon and wearing a wig. Do you see where I'm going? He and his team did all this stuff, including fake UPS cap, posing as a Mormon, and wearing a wig. Where is the Oxford comma? Y'all are going to be like, this is nerd stuff. Who cares? Well, let me show you why it matters. Because here's your English lesson for the day, your English grammar lesson. If it were written like this is not big enough. Let me see. Can I make it like 50 font? There we go. Was the kid, we watched the body camera footage yesterday together. Was the young man Christian? Thank you. The young man Christian, was he wearing a wig? Was he ever accused of wearing a wig? Was he ever accused of wearing a wig? No, that was obviously his hair. Yes, and I believe this is intentional. This is intentional because why? As MLS says, so the structure of this sentence, how it is written by the Wall Street Journal, implies that a fake Mormon wearing a wig and a UPS hat showed up in one event, and all of that happened after Ben had been trespassed. Who was wearing the wig? I never saw anybody accused of wearing a wig. Maybe the UPS kid, but then why would they put the fake Mormon here? It's making it seem like antics and ruses happened after being trespassed. In response to being trespassed, someone dressed up as a Mormon and wore a wig at the same time, and possibly also maybe the fake UPS cap thing. The fact they didn't put a comma here, the intentional leaving out of the Oxford comma, I believe is intentional, and I believe it is to make it appear as though Ben was doing more than he actually did. To make it seem like he was out here clowning around, wearing wigs, pretending to be a Mormon in a wig. None of that was in response to being trespassed, by the way, except perhaps the one Mormon kid showing up, but he wasn't wearing a wig. I want to look at the style guide of the Wall Street Journal. I want to say Wall Street Journal Oxford, style guide. Do they default to? They omit it. They avoid the serial comma. Look. I didn't even look at this. I hadn't even looked at this. I just looked it up right now, and I was right. The Wall Street Journal usually doesn't use that Oxford comma. Okay, fine. But what does it say here? While the Wall Street Journal generally avoids the serial or Oxford comma to promote concise, snappy sentence structure, their style book and editors allow exceptions when its absence creates ambiguity. So it is ambiguous. It makes it seem like he was a Mormon. He was dressed up as a Mormon and wearing a wig. Like that is also, we also talked yesterday about the fact that the kid was not a fake Mormon. He was a real Mormon. So the whole sentence is just completely misleading. And who was it who said, I don't remember who said it. There was no proof the kid wasn't an actual Mormon. Exactly. That's Gemini. I would check it. Okay, fine. Wall Street Journal style guide. All right, we're here. Can I search it? Style and substance, text, corporate jargon. Okay, let me go. Punctuation. Okay, they follow the AP. So AP style guide, punctuation, comma. Okay, this is a very credible source. Purdue Online Writing Lab, we would always refer to. This is the AP Style Guide, is short for the Associated Press. Associated Press Style provides guidelines for news writing. Many newspapers use the AP style in the United States, although some publications, such as the New York Times, have their own specific style guides. So for a complete guide to AP style, writers should consult the most recent edition of the Associated Press Style Book. We're doing this because somebody said that was Gemini and I should look at this myself. Search style book. Let's search serial, comma. No results. Okay, let's just go Oxford, comma. Oops. Okay. Help Center. Okay, where is it? Let's see. Help Center is designed to provide assistance considering our products. No, I don't want to have to buy something. I don't want. They make you buy something to tell you the rule. Of course they freaking do. AP Style Book Online. Look, they want me to buy it. No, we're not doing that. AP Style 2026. Serial, comma, Oxford, comma. Not buying shit. Okay. Rules related to the Oxford comma revisited. The subject of many debates, works of writing, and even at least one song, the Oxford comma is the last comma in a series of 3 or more elements before a conjunction and or. For example, while news outlets usually use AP, it generally does not require Oxford comma. Book publishers and academic journals usually use the Chicago Manual, which does require it. Meanwhile, okay, as with any rule, consistency is key. If the style guide you're following, okay, those who prefer it don't often point out. Okay, let's see. Nutella, Oreo, Yeah. Those who prefer to use the Oxford comma often point out multiple reasons to avoid not only potential confusion, but the possible need to add this comma anyway, or switching from using commas to semicolons. Always using the Oxford comma usually eliminates issues. Consider the potentially confusing example of a series written without the Oxford comma. Quote, the boy visiting the show's set was eager to see the actors, Grover and Ernie. Without the Oxford comma, the sentence could be read to mean that the child only wants to see 2 actors named Grover and Ernie. With the Oxford comma, one doesn't have to be familiar with the show Sesame Street to understand the boy is eager to see multiple actors. Okay, so where there is ambiguity, the exception is allowed. And I just think it's very interesting that this Oxford comma pretty much created a situation that looked like Ben himself or one of his team members was wearing a wig, dressing up like a fake Mormon, whereas the Wall Street Journal didn't bother to say that it didn't actually look like that was a fake Mormon at all. It's just aggravating. It's misleading. It's bad. Yeah, if your readers are confused, you failed. Exactly. Thanks so much to Scruffy Mans for the $2 super chat. It's AI slop news when they focus on non-important, or when they're lying, or when they're making things confusing and ambiguous. I think on purpose. Now, I will say, in their defense, counter argument, the Oxford comma isn't supposed to be used traditionally, typically in the AP style. But I think it's very convenient that not using the Oxford comma in this particular situation made it look like somebody was out there dressed as a Mormon in a wig. Okay. There was a barefoot wig wearing Mormon duck that stepped on a Lego and whom then called 911 threatening to shoot people. We didn't have no shoes on. Okay. So I wanted to point those things out as well. Okay. So the next thing I wanted to circle back around to is on this map, the BAM map. Shout out to the BAM map for putting this resource together. This is under the recent updates tab. And as you may remember from the coverage from yesterday, Bricks and Minifigs did put out, yeah, I agree, Virginia. Bricks and Minifigs did put out yet another press release. Now, basically, there wasn't really anything new in this press release. It aggravated me, though, as I mentioned earlier, because Brian Mansell, Victor, all of them, they're pretty much gagged at this point, and they're not able to talk. They're under this temporary restraining order not because of the criminal cases, because of the civil cases. And all the while, after accusing Brian Mansell of pretty much running a criminal enterprise, now they're using his name and his family's name in their freaking press release titles to be like, oh, we're still committed to resolving the dispute with him. Okay, well, y'all have him gagged right now, so you must not be that committed to it. It almost felt like a weird extortion. Like, we're going to keep terrorizing you. We're going to keep picking on you. We're going to keep basically lying or saying things that you cannot dispute and cannot even respond to because we have you under our TRO. Well, we read through that press release yesterday. Let me pull it up. They also put it on the Business Wire PR site as well. And we did read through it yesterday and talked about how it was full of misleading statements. I mean, it was like I was on my soapbox yesterday because of all the fake stuff that was being just put out in the news and to the public yesterday, when it's like, if you actually are on the ground following the story to the specific and granular degree of detail that we are here on this channel that I have, then it's like you can't help but just actually get like frustrated all the way up to like possibly infuriated to see how the stuff is being reported on by the Wall Street Journal, by News Nation, by Bricks and Minifigs themselves. There was something else I was aggravated about too earlier in the coverage of this case. I don't exactly remember now what it was, but it was like one of these mainstream, whatever. I know it does seem ironic that I've had 2 BAM series. It does seem ironic, and it's very confusing to me. I still like have a hard time saying BAM because to me BAM is Bam Margera. Thanks so much to Cargo Van Killa for the $10 super chat. The reason traditional journalism outlets get facts so wrong with such an egregious degree is because they are all written by AI now, and they barely proofread or fact check these by humans. And that's thank you for the $10. That's kind of what I was trying to say earlier. Like in the day of AI, like where we are now, I think I like it that I take such deep dives, into these things, because when I'm reading the news, you can't know what's real, what's not real. The news, Wall Street Journal, News Nation, TMZ. I mean, that's not really news. That's more like tabloids. But I mean, they put it out like it's supposed to be news. And unless you're just like following it on the ground day to day, have laid eyes on all these documents and dockets, then you might just be led astray. So this is where I'm going to continue to do that here. But thankfully and fortunately, the people over there at the bammap.com have gone through that statement, the Bricks and Minifigs corporate press release they put out yesterday, and have compared some of those statements to other public statements that Bricks and Minifigs themselves have made. That is so brilliant to me that I wanted to go over it. In the meantime, right before I get into that, I need to run to the bathroom real quick so I can lock in for fact checking these facts and showing the discrepancies. So I will be back in just a moment. Okay, I'm back. Just need to situate my headphones and all. Actually, I don't need them for the next segment. Okay. New filing. Okay, thank you, Mel Roy D'Souza. Break real quick from the regularly scheduled programming. Apparently, we have some new filings. So let's go take a detour over there first. Breaking news, new filings. What are they? Yes, nice. Okay, so we have, oh my God, girl. We have 3 new filings, and one of them is more important to me than the other. So, okay. These apparently were filed yesterday, but they did not hit the docket until today. And reason I think that is because we looked at the docket earlier, and these docket number 9 and 10 were not up there. See, it went from 7, 9, 10, 8. So the reason that the 9 and 10 are now coming before 8 is because these were actually filed but didn't hit the docket. These have to do with that Gregory C. Belmont guy. Okay, fine, whatever. That's interesting. But look at docket number 11. Joint motion for temporary restraining order modification and entry of preliminary injunction filed by defendants. Okay, so let me download this and let's read it. Thank you again, Melroy, for letting me know that there are new documents filed. Now, this is a 10-page long document. It appears as though the defendants rather, have come together to file another attempt at modifying the restraining order. Is it going to be exactly the same verbiage? Is it going to be different verbiage? Is it going to be, what's going to be going on here? So I'm downloading the document now. Just give me a moment. We'll take a look. It's 10 pages long, but it may not actually substantively be that long. Docket number 11. This is breaking. This just came out since I've been on live in the last 2 hours or so, maybe even less, maybe even under that. Okay, let's see, 30. It definitely did get docketed today. Docket number 11, joint motion for modify TRO and prelim injunction. Okay. All right. Let me just make sure there's no addresses and stuff listed here. All right. Just from the brief scroll I just did through this, it kind of does look like it's pretty much exactly the same thing that we've already seen, but now it's being filed in federal court. Now, interestingly, this was already denied. Sorry, I had something on my pants to make sure it wasn't wet. This seems like it was already denied at the state court level. I don't know why a federal judge would approve this, but let's take a look. Joint motion for modification of temporary restraining order and entry of preliminary injunction. Okay, so it is being filed by the plaintiffs and the defendants. So plaintiffs, as we know, this is again not the criminal case, this is a civil case. Plaintiffs, BAM Franchising, Ammon McNeff, Matthew McNeff, Josh Johnson, Baker Bricks doing business as Salem Baker Bricks, and defendants Ben, Reckless Ben, Brian Mansell, and Victor Gwynn jointly stipulate. Okay, so plaintiffs and defendants together, again, jointly stipulate, agree, and move the court to modify the temporary restraining order entered on June 9th, 2026 in the 4th District of 4th District Court for the state of Utah, and to convert such into a preliminary injunction in order to permit the parties to engage in settlement discussions and or mediation. Okay? So far seems similar to what we've already seen, to what we've already read. Settlement discussions and or mediation following an exchange of relevant documents and other information. Okay, so they're doing it seems like some preliminary discovery with each other. Plaintiffs allege, okay, so this is Bricks and Minifigs and BAM, parties, the ones suing. They allege they're suffering and will continue to suffer immediate and irreparable injury before this action can be fully heard, as set forth in their complaint and motion for restraining order, temporary restraining order filed in Utah, submitted to this court, and the notice of removal. The defendants dispute. So Reckless Ben LLC, Brian Mansell, and Victor dispute these allegations made by plaintiffs. They're not admitting to any of this. They intend to assert counterclaims against plaintiffs and contest plaintiffs' entitlement to any relief, including but not limited to a permanent injunction. Plaintiffs likewise dispute defendants' counterclaims, and I believe this is going to come in the form of a anti-SLAPP motion or something like that, but we'll just have to see. Despite these differences, okay, so defendants, Ben, Victor, Reckless Ben, all them, they dispute all this stuff that the plaintiffs, Bam and them, are saying. They dispute it. Likewise, Bam and them dispute any counterclaims. So nobody is admitting to anything. Despite these disagreements or differences, the parties have agreed to mediate this case, and in light of this, they jointly move the court to enter a preliminary injunction in the form attached as Exhibit A. So we'll take a look at that. Despite these different, okay, defendants agree. Okay. So this is the summary. Defendants agree. This will be Bam. I always do that. Defendants agree. This will be Ben. This will be Victor. This will be Brian Mansell. Agree that their affiliates, employees, contractors, agents, representatives, and anyone acting in concert with them directly or indirectly, in person, remotely, or online, are immediately restrained. So they agree. I don't know how they're going to keep their affiliates, employees, contractors, agents, and representatives from being able to do something. I really don't know how they're going to be able to stop somebody. Making, transmitting, soliciting, encouraging, and or facilitating death threats, bomb threats, or other threats of physical violence, and or knowingly or intentionally engaging in property destruction, stalking, trespass, interference, extortion, personal injury, or property damage against plaintiffs, their independent franchisees, employees, officers, owners, customers, attorneys, vendors, or family members. It's still so overly broad, and I'm going to say I still unfortunately have to agree with Judge Tony Graff. How is Ben supposed to know? How is Victor supposed to know? How is Brian Mansell supposed to know? Every independent franchisee, every employee of a brick and a minifig, every officer, every owner, every customer of a brick and a minifig, all attorneys, vendors, family members, like how could they possibly know who these people are to stay away from them? Publishing or encouraging others to publish personal addresses, personal phone numbers, personal email addresses, family information, or other doxing information of any kind. What is this family information crap? Was that on the first one? Let me do a compare real quick. What was that docket number? Opposition, notice of change circumstances, I've noticed, standing decorum order. When was that? The 24th? Motion for modification of TRO. I want to compare. No, it said that in the first one. Okay, I just wanted to check. Okay. So, defendants agree that not only they, but also their affiliates, employees, contractors, agents, and representatives, and anyone, quote, acting in concert with them, will be restrained from publishing or encouraging others to publish, quote, family information. This is crazy. I don't know what, honestly, I want to trust Ben's lawyers and stuff. I don't know what they're thinking here. So they can't say anything about any family member at all, not even their name. Or other, quote, doxing information, which doxing is a legal term of, like a legal term. It has a definition. It's not just somebody said it was doxing, so it's doxing. Regarding plaintiff's personnel, franchisees, owners, or employees entering, remaining at, filming, blocking access to, or approaching within a defined distance of the franchisee's stores, offices, warehouses, franchise locations, parking areas, employee homes, franchisee homes hereafter, except through counsel, lawful service. So you can't even go to the parking lot of a brick and a minifig. Impersonation of any franchisee or any of the plaintiffs, law enforcement, a court officer, a delivery service, a customer, a government entity, employee, or any other third party to obtain signatures, access, statements, employee info, audio, video recordings, customer information. This is too broad. Touching, altering, covering, defacing, or placing signage or any other form of communication affecting plaintiffs or their franchisees' physical property, physically blocking, deterring, or interfering with customers, employees, vendors, or delivery personnel doing business with plaintiffs or their franchisees in any way. This is way too broad. I don't know why they would agree to this. Soliciting plaintiffs' employees, franchisees, or contractors to leak confidential information, record inside stores without authorization, obtain phone numbers or private information, or create or participate in staged confrontations. Subject to the foregoing, nothing in this order shall prohibit Ben and them from discussing plaintiffs, commenting on this litigation, publishing court filings, engaging in investigative journalism, expressing opinions, criticism, satire, or commentary through any lawful means, methods they choose, including but not limited to YouTube, TikTok, Instagram, and podcasts, or other internet, television, radio, and social media platforms. How do you agree to not talk about family information when Dan McNeff was the CEO of this company? I don't know. I don't like this order at all. I actually agree with the judge that said, no, we're not doing this. Plaintiffs shall not be required to pay a security bond. They should. At least he's like, I'm making YouTube videos. The preliminary injunction will remain in effect until further order of the court. Nothing in the preliminary injunction shall be construed as a waiver of any party's defenses and right to pursue past, present, or future claims or damages against any other party. And all the lawyers signed it, order granting the motion. So this is what the order would look like that they want the judge to sign. It's obviously not yet signed. This is the magistrate. Now, before any and all of this, I do wonder, do they need to consent to the magistrate judge having jurisdiction over them in the first place? Do they first have to consent? Let me go back to the PACER page. I'm just confused as to why the defendant's side would agree to this. Me too. It has not been signed. Let me see if it's the same signature. No, it's signed as of today. So this is new signatures, legally speaking. Let's go back to the docket page and see not only what has already been filed that we know about, but if anything else. Just wondering, can the judge edit or modify this order and then not sign it? Oh, then sign it? I don't think so. I don't think the judge can just edit it and then sign it. The judge can offer suggestions and then they can make the edits and then they can sign it. But I don't think the judge can just edit it and sign it. I don't think. Maybe someone knows better than me. Melody said, I feel like Ben and everybody just wants to start here so Ben can then publish part 3 and move forward from there. Yeah, maybe, but this kind of feels like something that's like a bear trap. Like they're going to be able to like somehow mutate this stupid thing to harm Ben. Notice of email filing notification from Gregory Belmont. Motion to intervene filed by Gregory C. Belmont. Girl, he gets on my nerves, but okay, fine. 52 pages. It's loading. Okay, I'm just going to save this so I don't have to keep buying it. So just give me a moment and I'll pull this up. This is that guy that's like the Patreon, the AI guy, the Patreon subscriber. Okay, this is docket number 10. Refiled motion to intervene for limited purpose and for declaratory relief declaring the state temporary restraining order expired. Oh, okay, actually this is something new. So this Gregory C. Belmont guy is asking the court to declare that temporary restraining order is expired. We did do a little bit of an analysis of this earlier today. Proposed intervener Gregory C. Belmont respectfully moves this court to enter. Respectfully moves this court under federal rules of civil procedure to intervene in this action for the limited purpose of challenging the speech restrictive provisions of the temporary restraining order. Notes this application was originally filed at the state court level and was denied without prejudice by operation of law because it was removed to federal court. He has federalized this refiled motion to assert audience side constitutional claims. This looks so AI. And threshold declaration. Okay, expedited. He wants the judge or the magistrate to decide quickly. They want a declaratory order finding that the state court's ex parte TRO expired automatically by operation of law. This is probably the most interesting part of this to me. Oops. I want to put a box. Oops. So he wants this federal magistrate to pretty much say, hey, remember that temporary restraining order? That's expired and it's over. I don't know if he can do that or not. I mean, he's doing it. I don't know if it's procedurally proper or not. And the alternative, if you can't do that, Your Honor, any portion of the state court temporary restraining order that is deemed to survive gets a granny goose holding, completely vacating paragraphs 5J and 5K in their entirety as unconstitutional, pre-adjudication content takedown mandates as vague, overbroad, and prior restraints. Now, that part I do agree with. I don't know if he has the standing to do it. He's asking for the judge to order any speech protective provisions, safe harbors, or commentary allowances be carved out for the named defendants in a preliminary injunction by explicitly extending to cover all independent non-parties. I really don't think this person legally has standing. It's not that I don't think he has strong arguments. I do think he has strong arguments. The issue is Reckless Ben has 1.5 or whatever million YouTube subscribers. Add that on top of the however many thousands of Patreon subscribers he has. It would be, I think, argument ad absurdum, right? Like it would produce an absurd scenario if we were to follow the argument to its logical conclusion. This is a type of logical not really a typological fallacy, but it's similar to that. It's a type of, it's called statutory construction. And it's where you're, dealing with instances upon first instance, or you're trying to figure out what the legislators actually meant when they wrote a law. It's a statutory construction. And so it does seem absurd to think that any and every individual who subscribes to a YouTuber has standing to start filing all kind of stuff in a right of action, in a cause of action that has nothing to do with naming them directly. It would end up being possibly a million of us filing stuff in state court, or federal court, which would not seem like that was something that was ever intended, or not seem like something that could efficiently even possibly be tenable. That is why I am always talking about, I don't think he has standing. It's not that I don't think he has strong arguments. He makes great arguments. A lot of his arguments I totally agree with, like that this TRO is speech prohibitive, and that it's unconstitutional, and that it's a prior restraint on speech, and all of that. Not only for Ben, but it could also possibly be extended to apply to not only people we know about, including Sheldon or Tyler Shaw or Crystal Law or Ben Gorman, but also could be, who's to say, because maybe I promoted somebody's GoFundMe, now they're going to say I'm acting in concert with them, even though I never talked to them. Once they start pulling someone in by name, of course, I think they have standing at that point to file things and to file motions. That being said, I really don't know. This is my opinion. No, I wouldn't interview Gregory C. Belmont. No, I have no desire to do that. I really don't like interviewing people at all. Okay, so that's that. And so, like I said, I don't disagree with some of the points he's making. Actually, I do agree with some of the points he's making. I just don't know if it's going to get very far. I don't know if it's going to make it higher than the ceiling. I'll say that. Maybe the defendant was pretty sure the judge would reject and show what Bam is really up to. Maybe. Let me see. If anything else has been filed. Because I know nothing else yet. Okay. All right. Okay. So, where were we? Here. Okay. So we know about this press release, although yesterday we did look at it on the actual Bricks and Minifigs website. Today I have it pulled up on businesswire.com. And I think it's the same press release. Now, I do find it interesting that they always use this Lego with the little registered R trademark thing here. And I want to talk a little bit more about that later when we get into this theory. But we did have the bammap.com come through and make a little bit of a fact check here. Let me read this. This came out yesterday. On June 29th, which was also yesterday, Bricks and Minifigs issued a statement titled "Determined to Find Amicable Resolution with the Mansell Family." Again, totally infuriating, totally unfair. They're mentioning the Mansell family by name while also simultaneously accusing Brian Mansell of running a criminal organization. The BAMAP said, "We checked its claims," the claims in the press release of the Bricks and Minifigs press release, "against the two documents BAM cannot disown." Okay? Which ones? Which documents? The 2026 franchise disclosure document. So I don't know what they mean when they say 2026 franchise disclosure documents, because there is a 2025 franchise disclosure document, but that one was signed in 2026. So I'm going to assume that's the one they mean, and that is the only one I have. So, I know I got the ADHD. I know the mic is shaking because I'm bouncing. I always got to move my foot. My brain don't work. My brain don't work unless I'm like bouncing or moving or swaying, or it's like I need to be moving for my brain to operate. Is that ADHD? I don't know. Maybe it is. Maybe that's the ADHD girl. I don't know. It's okay. So I do have the 2025 one, and I'll take a look at that one. I do have it pulled up here, and also the verified complaint filed in court. Okay, so what's going on here? The BAM map, I think really smart, I think really helpful, and we're going to go through it. They took 3 documents or 3 public writings which were put out by BAM itself, all of which put out to the public by BAM. One of them, the press release that came out yesterday. One of them, the franchise disclosure document, and one of them, the actual lawsuit they filed themselves. So they said, all right, bet, let's compare across those 3 documents what's going on here. Let's see if all these statements they make in these documents can be reconciled with one another. Spoiler alert, no. There's a lot of contradictions, we'll say that. 4 of the central claims of the press release are contradicted on the face of these documents. 2 of their claims are concessions that match what the record already showed, and the rest is hedging. Remember whenever I said yesterday we were reading this stuff, I said this is hedging language. It is believed that purportedly the so-called and all of that, it is reported apparently, that all that hedging language. Every counterpoint below carries the exact line or paragraph. One note up front: in fairness, the statement is written almost entirely in qualifiers. Believes and alleges, apparently, seems to align, believed to have. It is a legal filing in the shape of a press release, and we grade it as one. Okay, so their first point is this quote right here. Quote, consignment is not part of the company's business model. Remember we read that yesterday in the press release? Put a 4 in the chat if you remember reading. Consignments are not part of the company's business model, nor are they authorized by the franchise agreements expressly. They are expressly limited. So this is a refuted claim. And refuted by whom and refuted by what? We're not even going out here and getting Josh Johnson's statements. No. We're only comparing Bricks and Minifigs statements themselves. Consignment. Okay, so here's one claim. Consignment is not part of the company's business model. It's not authorized. Okay, well, that's refuted. In the 2026 franchise disclosure document, in the section of the franchise agreement that defines what a franchise does, it states that a franchisee, quote, may also offer consignment services. Okay? The flat claim that that consignments are not authorized by the franchise agreements is actually contradicted by the franchise agreement, which is public and has been made public by, I believe, Crystal in her lawsuit. Bricks and Minifigs' narrower gloss, the consignment is expressly limited to venue and event fees, and that the consignment allowances were never supposed to extend to actual Lego bricks, and was only supposed to apply to like birthday parties and events, and never extended to acquiring Lego products. This appears nowhere in the franchise disclosure statement. The document lists consignment services with no restriction. Whether the franchisor would have approved this specific Lego consignment arrangement is a fair question because it was a lot of Legos. But the menu item is offered, approved by us, but we never authorize consignment. This is not what BAM's own agreement says. So I have the franchise agreement that actually Crystal Law herself included in her own lawsuit. Okay, so I have her actual one as an exhibit. It was Exhibit B. Before we get to that, I just want to look at the actual press release. This is, again, I'm just going to read this one paragraph and then this sentence below. Quote, and this is from Eamon McNabb, quote, this came out yesterday in his press release. We understand why this story has stirred so much emotion, and we don't take that lightly. We also want to reinforce that this is an isolated, unfortunate incident related to a single franchisee who did not obtain an approval for any consignment arrangement. Okay, so What do you mean did not obtain an approval? So you are conceding then that there are some situations and circumstances under which you would have approved a consignment agreement, or are they never ever allowed? Which one is it? That's a contradiction within the four corners of this document itself. Ammon goes on, it does not undermine the integrity of our more than 300 other independent and unrelated franchisees. Our goal has never changed. Help make this family whole, enhance operational processes, and build a company our franchisees and customers can be proud of for years to come. All right. Unauthorized consignment arrangement. The apparent underlying consignment arrangement for Lego products is not part of the company's business model. It is not authorized by Bricks and Minifigs. It's not authorized by the franchise agreements. Nor is it authorized a consignment agreement, nor are they authorized by the operations manual. So-called consignment services, so-called, okay, who called them that? You, in your own franchise agreement. So-called consignment services are expressly limited and only allowed for service or experience-based partnerships, such as venue or space usage fees, revenue share, or commission on service fees, referral or facilitation fees for bookings made through a store, or bundling as add-ons to Bricks and Minifigs hosted parties and events. Consignment services do not include and have never been extended to include acquiring Lego products. Bricks and Minifigs operates strictly on a buy, sell, trade model. Bricks and Minifigs corporate does not authorize franchisees to enter into third-party consignment arrangements for Lego products. Bricks and Minifigs did not authorize or sign any consignment arrangement respecting the Salem store's alleged arrangement with Brian Mansell. Okay. That says unequivocally, explicitly, consignment arrangements for Lego products is not part of the business model and not authorized by the franchise agreements. Okay, cool. I got the franchise agreement. Let's pull it up. And I got the exact same one, Crystal Law, included in her lawsuit. This is the exact franchise agreement. Now, Bam Map says that contradicted in the agreement's face. Breaks many things never go. Consignment for limited venue the fees never extended acquiring Lego products. There's nowhere in the FTD the document lists consignment services. Okay, so let's check out consignment services. I'm going to Control F. This appears on page 4. Oh, excuse me, page 6 of 87, but the numbered page is page 4. This is in the introduction. All right. Here's the franchise agreement. This franchise agreement is made February 3rd, 2023, by and between BAM Franchising and BAMF Salem 1, which is a limited liability company that was owned by, I believe it was, hold on, let me do this. I believe it was Crystal and Ben, but maybe it possibly was just Crystal on the company. Okay. So this is the franchise agreement made February 3rd, 2023 between BAM Franchising and BAMF Salem 1, which was Crystal's company. The company and franchisee are sometimes collectively referred to as the parties. Okay, so introduction. Bricks and Minifigs. We own, operate, and franchise Bricks and Minifigs businesses. These are retail stores typically located in shopping malls, strip malls, or as freestanding structures, featuring high-quality Lego products, related merchandise. We and our affiliates have developed and own a comprehensive system for developing and operating Bricks and Minifigs stores, which includes trademarks, distinctive store designs and layouts, decor and color schemes, vendor relationships, resale methods, advertising methods and strategies, specifications, procedures for quality control, marketing materials, training programs, and certain operational and business standards and policies. All of which we may improve, further develop, or otherwise modify. A Bricks and Minifigs franchise will. Okay, so what will the franchise do? A franchise will provide programs permitting customers to sell and or trade their used Lego bricks, Lego minifigures, and accessories. The franchise will offer for sale a wide selection of new and used Lego bricks, Lego minifigures, and accessories sold in bulk or full play sets, in addition to selling apparel and pre-loved non-Lego branded and or Lego compatible products and other merchandise approved by us. Okay, so this is the products. Okay, so what is the products? The products is a wide selection of new and used Legos, Lego minifigs, accessories sold in bulk or full play sets, in addition to selling apparel. Pre-approved, non-Lego branded. So this is the stuff like if you want to sell something that's not Lego brand, you have to get approval. Okay, fine. And other compatible products that are not Lego, but they're compatible with Lego, other merchandise approved by us. Hopefully in this 87 pages, they were going to tell us somewhere what the approval process was supposed to be. Additionally, a franchisee, that would be like Crystal under this specific agreement, or BAMF Salem 1, may, okay, so may is different than shall. We've talked about shall. Shall means you don't have an option. May means you have an option. So they may, if they so elect, offer consignment services, approved themed entertainment services, such as birthday parties, holiday parties, school events, approved off-site events. Okay, this is a huge deal to me. This is one of those statutory construction things again. And I know it seems nitpicky, but like this is exactly my wheelhouse. Like I'm a linguist, I'm an English major, I went to law school, I passed the bar. Like language is my thing. This is the thing I pay attention to. So if you don't like it, you could go. I think a lot of y'all do like it though. When you're trying to figure out what something meant, what the people who wrote the thing actually meant, there's a bunch of tools you can use at your disposal. Okay. One of the tools I told y'all about earlier is this argument ad absurdum thing where it's like, you generally are going to assume the person who wrote the contract didn't want some crazy, absurd, undesirable outcome. Okay. That's one of the tools in the statutory construction belt or in the contract construction belt. When you're trying to figure out what the parties actually probably agreed to. Like, what would a reasonable person agree to? Hopefully, it's all just sitting there unambiguously in the four corners of the contract, but a lot of times it's not. And there's some room, there's some wiggle room. What I notice here, okay, this is the part we're looking at. Additionally, franchisee, that would be Crystal, may offer consignment services. Okay, what else? Approved themed entertainment services, meaning birthday parties. Let's say they wanted to have a themed birthday party. They could do that as long as it's approved. Also, off-site events, after school, project-based programs, teaching principles of building with Lego. Okay, fine. Approved off-site events. Got it. And other toy-related services approved by us. Now, what do we have here? We have a list, another list. It's a serial list, a series of things, widgets, a series of widgets a franchisee may, if they so elect, to offer. It's 4 things. 1 is consignment services. 1 is themed entertainment services. This is like a birthday party. Number three, that was number 2. Number 3, after school project-based programs. Okay, so one would be like birthday party, holiday party, but one's after school. Okay, that's the 3rd one. Also must be approved. And other, no Oxford comma, but still, number 4, other toy-related services approved by us. Of all 4 of those things, this is my first time reading through this closely. Of all four of those things, consignment services, entertainment services that like birthday parties, off-site events, and other toy-related services, 3 of the 4 have attached to them the word approved. That tells me whoever drafted this agreement was thinking about approval of certain things and requiring that if Crystal wants to exercise her right or her, right under the contract to do these things, 3 of these 4 need to be approved. Which one does not have to be approved? Pop quiz. Which one of the 4 does not have the word approved attached to it? Consignment services. That's a big deal to me. They went out of their way to type the word approved on everything else. Franchisee may offer consignment services. Does it say if they're approved by us? No. It just says she wants to. May offer approved themed entertainment services. Okay, well, that lets me know birthday party got to be approved. Got it. Off-site events. Well, those got to be approved. Got it. That's an event. After school project-based program. That one doesn't say approved. So I guess, I guess this approved could apply to that or not. And other toy-related services approved by us. They went out of their way to attach the word approved to everything else except consignment services. But then yesterday in their press release, they explicitly state that consignment services are not allowed at all, and they never approved the consignment service. So it kind of makes it seem like they didn't even pick a side. Are they actually allowed or not? But even if they are, do they need to be approved? Nothing in this franchise disclosure agreement prohibits consignment services. Nothing prohibits consignment services. And yet yesterday in Bricks and Minifigs' statement, they explicitly state exactly the opposite. Let me remind you what it says. The apparent hedging language, underlying consignment arrangement for Lego products is not part of the company's business model or authorized by the franchise agreements or operations manual. So let's tear this apart. The consignment arrangement is not authorized by the franchise agreement. The consignment arrangement is not authorized by the franchise agreements. Okay, let's look at the franchise agreement Crystal signed. Crystal may offer consignment services. I feel gaslit. Okay. Let's get to some more discrepancies. I think we pretty much beat that one into the ground. I think y'all get that is obviously irreconcilable. The franchise agreement clearly allows consignment services. Now, if they another tool in your belt of statutory construction is plain meaning. That's the very first one you go to. You have to construct a contract or a law first using the most obvious plain meaning of a word. The most obvious plain meaning of this word is Crystal was allowed to offer consignment services. It does not say anything about needing to be approved. But then later on, yesterday specifically, Bam Bricks and Minifigs says, oh, the franchise agreements don't authorize consignment services. False. It's false. The plain meaning of the franchise agreement clearly authorizes consignment services, and I'll take you a step further. It doesn't prohibit them. Let's look up consignment again. There's only one instance when you do a control F of consignment services, and it's right here. She may offer consignment services, period. Approved parties, approved off-site events, after-school project-based programs, approved toy-related services, but nothing about consignment services needed to be approved. So now Bricks and Minifigs is like, oh, well, she wasn't even allowed to do a consignment agreement, and if she was allowed to do it, she was supposed to get our approval. None of that's true, based on the plain meaning of the contract. And David made a good point. I think I actually have this on my notes. Was it you, David, who said this? No, it was Greg Taylor. Let me show y'all what Greg Taylor said. Very similar to what David is saying here. This is a comment someone left. Fine. Let's say they didn't allow consignment. Let's just say. All right, let's say we didn't just completely obliterate and annihilate that argument for a second. Let's say it was true, their little fake, what they're making up fantasy now, okay? There is no comma, so it is kind of ambiguous. It's true. But everything else says approved. Let's say it is true. Let's say somehow, some way in this contract, they actually had written no consignment allowed. And Crystal did it anyway. She broke the rule. It don't matter. You still can't steal somebody else's property. They admit yet again in this statement they have property that does not belong to them, and yet still they have not given it back or compensated Brian for it. And they sued him for wanting his stuff back. Legally mine. I've had that song stuck in my head. All right. Let's move on to the next statement. The document lists consignment services with no restriction. Whether the franchisor would have approved this arrangement is a fair question. The menu is offered approved by us, but we never authorized consignment. Right, which one is it? Okay, next statement. Let's see if we can obliterate the next statement and find some contradictions from BAM itself. Because what we're doing here is very, very powerful. It's way more powerful than just like, oh, let's look at that's a Class A misdemeanor. Class A misdemeanor to do a consignment service. This is BAM's own words being used against them. This is BAM's own words being used against them. Quote, triggered the company's repossession pursuant to its security interest in any on-site inventory. So let me find that part. I did spend some time on this yesterday. Bricks and Minifigs believes, as of November 2024, Crystal had stopped making payments. This is crazy to me too, by the way, that they could believe this. Like, aren't they the only ones in the position to know if this is true or not? Maybe Crystal as well. But they're like, oh, we believe she stopped making payments. She either did or she didn't, and y'all know it. You don't have your books and records together? Anyway, as of November 2024, Crystal had stopped making payments on the purchase of the location, had not paid royalties for multiple months, and she owed, quote, tens of thousands of dollars in other unpaid expenses. Now, this is up for debate. Crystal claims that she had been trying to make payments to them and they wouldn't accept the payments. But let's just take, again, only BAM's word for it. Let's only take Bricks and Minifigs' word for it, holding it to the side that Crystal has disputed this and this will be litigated. Let's hold it to the side for a moment for the purpose of this analysis. Bricks and Minifigs, as of November 2024, believes Crystal Law had stopped making payments on the purchase of the location, had not paid royalties for multiple months, and she supposedly owed tens of thousands of dollars in other unpaid expenses. Well, it sounds like y'all are charging people too much. At the time of her announced departure, hold on, I thought it was she abandoned the store. Now it's an announced departure. Okay, got it. She owed, quote, substantial monies to Bricks and Minifigs. Again, she disputes this, which triggered the company's repossession pursuant to its security interest in any on-site inventory. Security interest means there's some ownership in it. It has some ownership right, some right to it. So BAM Map said, hold on. Bricks and Minifigs' complaint does plead a security agreement with the franchisee, so grant the security interest for argument's sake. Let's just claim that there is one. A security interest reaches the borrower's own collateral. Okay, what is a security interest? Like whenever you tell somebody, all right, if I default on my loan, you come take my property. I'm gonna put up I'm gonna get a mortgage on my house. If I stop paying the bank for the mortgage, they come take the house. I'll set up a financing plan on my car, and if I stop paying on the car, they come take the car. The person who helped you to finance the car, or the entity, has a security interest in the collateral, in the car. Now, let's say the bank gives you a mortgage on your house. You stop making payments. The bank wants to come take your house. They can't do that or something. And instead of coming to take your house, or maybe in addition to coming to take your house, they also go next door and take your neighbor's house. And then that's not enough for them. Then they go next door to that neighbor and take that neighbor's house. And then they start taking all y'all's cars. It feels wrong, right? Like that doesn't feel right, right? Like what do you mean? You have no interest in my neighbor's car. What do you mean you're going to come take my neighbor's car? What the f does that have to do with you? Well, the neighbor's car was parked in your garage one time. Okay, but I don't own that car. Well, didn't you borrow the neighbor's car one time? So that's my car now. No. Well, didn't you tell the neighbor that you were going to sell that car for him? Yeah, I was going to list it on Craigslist for him. Does that mean that you now owe that car to the bank? Hell no. Obviously not. Obviously not. And the dog and the goat. So that's kind of like what this is saying here. The security interest, fine. We don't even know if they did have a security interest in this inventory, but let's just pretend they did. The security interest would only reach Crystal's property. It would only be what Crystal or BAMF Salem 1 more specifically owned. It does not reach goods owned by a third party. And what do we know about these Legos? They were not owned by Crystal because she had not sold them, even under the consignment agreement. They weren't sold. There was inventory inside the store that didn't belong to Crystal. So there was no possibility that Bricks and Minifigs could have an ownership interest in something that the borrower herself didn't own. That's like saying, I'm coming take your daughter's dog. I'm coming take your next door neighbor's car. No, you're freaking out. What are you talking about? You don't get to have a security interest in finders keepers. Oh, and we're going to take the store next door too, because you owe us money. They can only take something from the person who is the borrower or who does have their name on the contract. Bricks and Minifigs 1, Salem 1, LLC or Inc. or whatever it was. That's the only property that we could be having a security interest in on the part of BAM is stuff Crystal owns. But if Crystal doesn't own it, Bricks and Minifigs has no security interest in it. Does this make sense? Or does it sound like I'm speaking like another language? Put a 5, makes sense. Put a 5 in the chat, it makes sense. Okay. A security interest reaches the borrower's own collateral. So only stuff Crystal owns, or the BAMF Salem 1. It does not reach goods Brian Mansell owns. The decisive document is one BAM attached to its own complaint. The consignment agreement states consigned merchandise shall remain the property of Brian Mansell until it is sold. A franchisee cannot pledge, so Crystal could not pledge, and a franchisor, Bricks and Minifigs, cannot take under security any interest, goods, or items, property that the franchisee, Crystal, doesn't own. Whatever Crystal owed, whatever money she owed, the collection was not hers to forfeit. It didn't belong to her. She did not purchase it outright. She was just holding it, storing it. For completeness, the franchise disclosure document grants BAM no security interest in franchisee inventory and no repossession at all. The word appears 0 times in 80-something pages. The only termination mechanism in Section 15E is to purchase the franchisee's own assets with title conveyed free and clear of liens. And so pretty much what the franchise disclosure document does allow is, let's say there was some inventory in the store. BAM could then purchase it from Crystal if she really did own it. But first of all, she didn't. And second of all, this part right here, free and clear of any liens, free and clear of liens. It's not free and clear of liens. There's a lien on the property because she does not own it. It's Brian Mansell's property. So again, they contradict themselves with their own documents. Number 3, the new owners, Brandon Best. Okay, so this is from the statement, yesterday's statement. The new owners, Brandon Best and Joshua Johnson, took over the Salem location. They discovered a, quote, small number of Star Wars products. This I pointed out yesterday, and I'm glad they pointed it out on the BAM map. The new owners, Brandon Best and Josh Johnson, are not independent outsiders. They're corporate employees. For example, Bricks and Minifigs' own franchise disclosure document lists Josh Johnson among the BAM Franchising Inc. franchise sellers. At the franchisor's Provo headquarters, a person who sells the franchise on the company's behalf. He's like a salesperson selling franchises. Bricks and Minifigs' verified complaint against Ben also reads, Brandon Best was engaged. I need to sneeze. Brandon Best was engaged as a contracted inventory inspector for Bricks and Minifigs, who, quote, secured the location at the November 14th repossession, after which he and Joshua Johnson agreed to jointly do so and formed the successor company that took over the store. The franchisor's own recruiter and the franchisor's own, the corporate recruiter and the salesperson and the franchisor's own repossession inspector are the 2 men who ended up owning the store they cleared out. This is from their own RICO case. So then the fourth issue, the fourth discrepancy, more than 300 other independent and unrelated franchisees, and this is an isolated incident. These are 2 claims on the number of 300. The most recent count that Bricks and Minifigs has disclosed is its own item 20 on the the franchise disclosure document. And item 20 says there's only 217 franchise stores and 6 company-owned outlets. That would be 223 in total at the end of 2025. I don't know, maybe they opened, 77. Maybe they opened 77 stores this year in the last 6 months. Maybe. I mean, that would have to be what? No, it'd have to be 78 at least, because they said over 300 stores, more than 300 other independent and unrelated franchisees. Okay, so then we have to take out their 6 company owned. So it'd be 217. So they would have needed to start this year, since they, reported this to the government. They would have needed to open 84 stores, because it had to be more than 300. You think they opened 84 stores in the last 6 months? I think probably not. Bricks and Minifigs cites no source for this supposed more than 300 stores. And its latest disclosure is 223, but that's not independent and unrelated. The independent stores would be the ones that aren't corporate owned. That's how I would read it. On, quote, independent and unrelated, the FDD refutes it clearly. The same item 20 footnote says the company-owned outlets are owned and operated by entities in which one or more of our officers owns an interest. And item 2 discloses that Ammon and Matthew have owned Craigle LLC, their franchisee in Orem, their franchise in Orem, since 2017. At least one franchisee is the 2 top officers. That would be Ammon and his brother, the CEO and the CFO, or whatever he is. Whether this is a so-called isolated incident is also contested. Terminated and sued franchisees recur across Oregon and Texas, and the owners themselves are now circulating a no confidence petition. Now, I haven't been able to independently verify that that no confidence petition did actually indeed and in fact come from the owners. The IRS is going to have a field day with this. Unless their friends work over there too. I mean, the judges don't seem to be in any hurry to hold these people accountable. It seems like they're just really just more than happy to restrict Ben's speech. I'm going over here to the PACER to see if anything else new has been filed. It is about high time for stuff to start just hitting this docket. No, nothing new yet. I think there was a lawsuit in Texas, I think. And then, yep, the last relic, that's Florida as well. He claims that those things happened to him as well. Similar, he reported similar things happening. I did see this little quote. This was the Edward Snowden thing I pulled up on accident a while ago. I don't know why this showed up today, because it was posted 2 months ago, but it was just so on point. I wanted to read it to y'all. Edward Snowden said it perfectly when, quote, when exposing a crime is treated as committing a crime, you are being ruled by criminals. Pooh. Pooh. When exposing a crime is treated as committing a crime, you are being ruled by criminals. We are watching this play out in real time in the United States of America today and all over the world. The justice system has been completely weaponized against anyone who dares to speak the truth or expose the corruption of the elite ruling class, whether it's whistleblowers exposing government overreach, journalists uncovering the Epstein client list, or everyday citizens protesting at school board meetings or city hall meetings, city council meetings. The response from the establishment is always the same. Silence them, arrest them, destroy their lives. Meanwhile, the actual criminals in Washington, D.C., and Hollywood, and American Fork actually just walk free, protected by the very institutions that are actually supposed to uphold the law. We no longer have a blind justice system, if we ever did. We have a two-tiered system where the elites are above the law and the rest of us are targeted by it. They even go into the scripture. Maybe it came out the Book of Mormon, we don't know. Scripture warns us about this exact kind of corruption in Isaiah. Woe to those who call evil good and good evil, who put darkness for light and light for darkness, who put bitter for sweet and sweet for bitter. God's judgment will eventually fall on those who pervert justice. And if you don't believe in God, that's fine, because every action has a what? Every action has a what? Equal and or opposite reaction. So you don't have to believe in some type of, benevolent God. You don't have to believe in spirituality. You don't have to believe in anything spiritual or paranormal or any of that. Every action has an equal opposite reaction. This is a two-tiered justice system. I mean, really, this was it. When exposing a crime is treated as committing a crime, you are being ruled by criminals. And that brings me to this. That brings me back around to what Ben said. No, I don't want to have a protective order against me. No, I don't. He said, I look at cases of people doing really bad things and I expose them. So Joshua Aaron Johnson doesn't want to get exposed. So he's making up a lot of lies about me in order to, get me arrested before he gets exposed. That's what this whole thing is about. And so I would like to object because I want to defend myself. I want to clarify that. The judge said, okay, no, fuck you. You're guilty. I'm going to treat you as guilty until you prove innocent, even though that's not how the justice system works. And it's giving, when exposing a crime is treated as committing a crime, you're being ruled by criminals. You being ruled by criminals. Thanks so much to Zoom with Smokey for the $2. Last Relic has his contract from Bricks and Minifigs. Okay, cool. Thanks so much to Man Blossom for the $10 super chat. Since Ben was trying to collect Legos for Brian, is the following an apt comparison? An individual trespassing a tow truck and a driver to keep a car you have defaulted on. I don't know, because here's the thing. I'm like a little bit confused about those small claims things where it was like they borrowed money from this and then I'm actually confused about what the standing is going to end up being with the Lego collection, even for Brian Mansell, because technically hasn't he now assigned his ownership interest in some of these Legos to other people? So like, how would he be able to be compensated for something that his owner, now they could easily probably just give it back to him, but then I think that might harm their small claims cases. I'm interested to see how the lawyers sort that out. Thanks so much to Northern Rep for the $10 Canadian. I watched a stream this morning where one of the guys made a clear statement regarding the outstanding minifig figures, which showed up in baggies. Maybe contact the one not named in the lawsuit. I don't know what that means. Thank you for the $10 Canadian, though. Thank you to Zoom with Smokey Bear again for the $2. Thank you to Marcus for all the hair flips, for all the hair. Thank you. Thank you, Marcus, for the $2. Thank you for the encouragement as well. Boots that are made for stomping on the public LLC. I don't think they actually care about the small claim suits. They were meant as a means to an end. Oh, they're talking about Sheldon? Okay. What am I supposed to ask him again? Okay, what else do I have here? Okay. Then I saw another theory on Reddit I want to show to y'all. And this is just a theory. This is a theory. Someone posted this. This isn't really the point, but this is the post that it's on if you did want to go and look at it. Bricks and Minifigs wants us to trust the results of their investigation. Meanwhile, they have 3 instances of join our company newsletter in the footer of their website. Now, I just want to be, insert my opinion here. I really think the reason that it says join our company newsletter 3 different ways is because they really just want people's email addresses and they're not good at making websites. That's what I really think. I think they just want people's email addresses and they're not good at making websites, but it is kind of sloppy, right? Join our company newsletter, join our company newsletter, join our company newsletter. So I just want to make this disclaimer. I don't think this specifically is a good example of this theory that we're about to see, but the theory I do find to be interesting. I'm going to keep my eye on it. Corporate Bricktator on Reddit says, in their opinion, one key strategy of Bricks and Minifigs is trying to out SEO the Lego company itself. Okay, so when you type in Lego or whatever online, this person's theory is that maybe Bricks and Minifigs' strategy is to just be the first thing that comes up when you type in Lego. Or taken to an extension of this argument, which is not explicitly said here, but it got my, gears turning. Maybe they're not trying to out SEO Lego, but maybe they are trying to, or maybe they are trying to out SEO Lego, but maybe they're, in addition to that, trying to just sort of confuse people and make it seem like they are somehow more affiliated and associated with Lego than they actually are. Because here's the legal, people ask all the time, like, how can they legally sell Legos? Well, girl, I mean, if somebody owns something already, they can do whatever they want with it for the most part, as long as it's not against the law. If somebody buys, a pair of Jordans or one of those watches, the AP and the Swatch or whatever, so you can go and sell it somewhere for $2,000 if you want. You can go and sell it somewhere for whatever you want. You can go give it away. You can go set it on fire. You can do whatever you want with the thing once it's yours. It's your property. So Lego really cannot stop people from reselling Legos that they already own. So that's the first answer to that question. Like, how does Lego let them sell stuff? I mean, they don't. They don't have to let them. You could sell anything. Just the same way that I could auction off this this thing. I could say, okay, who highest bidders? The bids are starting at $333. That's mine. Lego can't stop me from selling that. Now, what Lego could do is they could stop Bricks and Minifigs from relying on their intellectual property to sell their Legos. They could say, kind of like when Last Relic did his interview, he said he got cease and desisted from Disney because he was playing, when he had his store, he was playing like a Disney movie or a Disney song or something in his store. And he got a letter from Disney like, you can't do that no more. You can't play Frozen songs or whatever. They can stop them from using the term authorized Lego reseller. Maybe. But they are legally authorized to resell whatever they want to. Now, what I find to be where it starts to get a little tricky, in my opinion. I'm not a copyright lawyer and never have been. There's like a separate bar even for those people. Is how they do like an authorized Lego reseller with a little registered R. Specializing in buying, selling, and trading Lego products. It doesn't say used. So it kind of, this theory right here from this Redditor did get me thinking, maybe I'm not completely convinced by this particular argument, but it's got me thinking other stuff. Like, is Bricks and Minifigs maybe like over relying on the Lego name and the Lego brand to make it seem like they are actually like, maybe, Lego does not have franchises. Their stores are all corporate stores. But is it maybe like Bricks and Minifigs is almost trying to like make it seem like they are like associated or affiliated with Lego, even though they're apparently not, supposedly. Maybe they are. I mean, I don't know. From what I keep hearing, they don't have specifically like a relationship with Lego other than maybe to be able to use their like Lego name on their stores and stuff. Maybe they got permission for that. If you can't convince them, confuse them. He was playing the Frozen movie. There's two kinds of consumers: buying directly from brick store Lego or online Lego. Okay, Lego Corp can deny stores to buy from them, often discounted. I don't think they buy directly from Lego, though. I don't think they do. I think they were trying to be able to do that, but I don't know if that contract ever went through. Maybe they did. Maybe they did, and I just didn't hear about it. They're not an authorized retailer, and this is exactly what my point is. Saying that they're an authorized reseller, what do they say? It almost looks like retailer. Authorized Lego reseller. That's not a retailer. So this is where I'm like, hold on. Linking and promoting their newsletter excessively on their website is one way to continue to undermine the Lego company. Again, I don't know if this is exactly a good example of that or if I'm convinced of it. But I do wonder, to what extent Lego is okay with them just like using their Lego with the R and stuff all over the place. The FAQ section on their statement is to make them the result for AI agents when someone searches the same or a similar question. The contract was due to go through, but it probably won't now after all of this. Thanks so much to Kevin Adams for the $2.99 Australia. Shout out to Australia, and shout out to the Australian cousins in the chat. In Australia, we have Lego certified stores. Gotcha. Let's check the Pacer again. Nothing else new here. There's no more, and then said there's no such thing as an authorized reseller. No one is authorizing resellers. That's what I'm saying. I'm an authorized Lego reseller. Want to know why? I have some Lego right here. I've got some Legos, this one and that one over there, and I could resell it to you. I'm authorized to do that by the law. I could sell this to you. I'm authorized to do that. Because no one can take away my authorization to do that because it's just something I own. The same way that I could sell you this ponytail holder. I could sell this online. I'm authorized to do that. So it is kind of like, okay, well, yeah, technically you're authorized. You're authorized to sell it. But it kind of makes it seem like we're authorized by Lego specifically, like we had to get authorized by them. A rising issue is fake copies of Lego sets. Lego has told their customer service employees not to mention bricks and minifigs and use them as a last resort when telling people where to buy them. Something along those lines. Thanks so much to Man Blossom. I've seen where store owners are paying for a discount corporate provides. I've even seen store owners saying that they are registered dealers, which is interesting. Which stores? Bricks and Minifigs or somebody else? I'd love to know the details of the case that resulted in American Fork officer Blackburn being jailed in 2023. Me too. There was a boxing event this year. The promoter mentioned he had a broadcast deal with YouTube, which apparently meant nothing, and the event was eventually canceled. Right. I have a broadcast deal with YouTube, and what does that mean? You're just going to play it on YouTube? From the BAM website, Lego is a trademark of the Lego group of companies which does not sponsor, authorize, or endorse this site. Okay, we're authorized Lego reseller, but they don't authorize us. Very interesting. Zoom with Smokey Bears said, well, they're not doing a good job because I Googled Lego and all I see is Lego stores. Authorized reselling reseller LLC. Sorry, authorized retailer. Oh. Authorized retailer. Now that's different than reseller, but then is it? You know, these are things that I wonder. These are things I wonder. Could you file for the officer's discipline records as public request for those involved in the case? I could. I mean, it would take a lot of time and effort, but I mean, I guess I could. I don't know if I will. Let me see what else I wanted to talk to y'all about today. So yeah, I mean, that's just an interesting theory. Like I said, I don't fully necessarily, the judge did not sign off on it. Did this just happen? Did that just happen? Let me type in the case number and I'm going to look on Court Listener because that actually showed up first on Court Listener before it showed up on Pacer. So let me see. Is this breaking news? I hope the judge didn't sign off on it. I know Ben and them agreed to it, but I think it kind of like is just it's too vague. That's my opinion. Let me do this. Hold on. 226-CV-00593. Oh, I did VC. No wonder. CV. So Ronald Preston, what do you mean, if you wouldn't mind clarifying, when you say the judge didn't sign off on it? Are you talking about the federal judge? I'm not seeing anything filed. That's why I asked. Or are you talking about Tony Graff from last week? There's nothing filed here. What a waste of paper. In my opinion, this was a training exercise in SWAT raids. Could have been. We honestly just need a sane judge to read the temporary restraining order and dismiss it. It clearly is not correct. Okay, let's look at this and see if there's been anything new filed here. Let me see how much money I have on my little account here. If I have enough to... Okay, hold on. I want to check the dockets of the other cases. 261. Four zero one 094. Just checking the docket. This one is for, nothing else new here. We're up to date here. Now I'm going to check that Provo case. That one supposedly has another hearing, has a hearing coming up, I think in next week, the 6th. Or would it be Friday? How many days does June have? June. So maybe that means, no, it's the 30th. First, second, third. Today's a Tuesday, Wednesday, Thursday, Friday. It'll have to be next week. Okay, so that case number is 261-000-376. Just checking our dockets here to see if we have any more filings. This is the Provo case. No, nothing since the 24th. Thank you so much to Volve 8 for the $10 Australian for some more file downloads. Thank you. Thank you, thank you, thank you. Great Spirit gave us a corruption case we can digest so we can learn to see clearly and band together, in my opinion. Could be. That's Stephen Schreiner on that case. Let's see what else has been posted in this Reddit. Any breaking news over there? Gregory Belmont is back. We already knew that. Bricks and Minifigs media push for the mainstream. This is my opinion too. So let me read y'all this. This person says, Bricks and Minifigs media push for the mainstream. I don't think the biased and incorrect and misleading Wall Street Journal article, the blog post, and now stores posting YouTube videos advertising themselves as a coincidence whatsoever. This is all just a way to see if they can sway the wider public with their lies, while no one from Ben's side can actually speak up for themselves because of the TRO. No franchisee has really said anything, and some have even responded to people by blaming Ben. Bricks and Minifigs store owners can't be trusted either. No, they can't. And it's not their fault. They're like all tied up with it. They have serious conflicts of interest because if Bricks and Minifigs goes down, they might not even be able to feed their families. I mean, you can't blame them for their loyalties, but like, come on, girl. Maybe just sit there and eat your food. Bricks and Minifigs store owners can't be trusted. At this point, they're all complicit at best and actively helping cover up. In others, the videos from the stores in the last 14 hours. So there's like, apparently stores are posting videos. I'm not going to click on those links right now because I don't know what the videos are. We knew about Belmont. I do think they are on a media push because there was the biased Wall Street Journal article that was wrong and full of misleading at best information. There was the very, very wrong and incorrect News Nation thing. There was also the very wrong and incorrect and misleading blog post, which then got also posted to Business Wire, and this all happened like quick, and all of it happened while in the last dying days of this unconstitutional, overly broad temporary restraining order. Let me read y'all I was so mad yesterday after I got off live because, I like kind of thought about it in this way, and I posted this post. I said, it is actually insane that Bricks and Minifigs got basically an indefinite temporary restraining order against Brian Mansell after accusing him in a lawsuit and to cops and to the public of leading a criminal enterprise. And while he is still currently gagged from their TRO, Bricks and Minifigs is making public statements using his name in their gaslighting ass blog title, saying that they're committed to a resolution. All while he can't even speak. Aggravating. Annoying. Abusive. And they put it in their title. What did they say? Committed to or determined to find amicable resolution with Mansell family. Oh, the same family whose Legos you stole? Oh, the same family who you also sent. I heard from Reddit that Bricks and Minifigs sent a TRO to the dying daddy, the daddy with cancer. The one who has the Legos in the first place. They sent the TRO over there to him. Oh, yeah, this applies to you, too. You can't talk either. And now they got the boldface, unmitigated gall and audacity to use the Mansell family in a title when the Mansell family ain't even allowed to utter their name. That is BS, to put it nicely. The Wall Street Journal author has family and American fork. Put a 5 in the chat if you are not surprised. I just put a 5. Thank you for the $2. No, you cannot see my ID. The Wall Street Journal article author has family and American fork. I mean, I haven't seen proof of that, but I definitely don't have a problem believing it. Thank you to Rose for the $1.99. Did you see the AI guy filed an intervention in federal? Yeah, I did. I pulled it up. I bought it and all that. 50-something pages. Thank you for the $1.99. It looked like a media push to me. I'll say that. Okay, y'all. Well, I don't think we're going to get to any of the body cam today, but that just gives us more things to do tomorrow. We are caught up in all the filings in all 3 of the cases. And that's really all I had for today. I'm kind of starting to get a migraine. I want to go lay down. So in the meantime, facts ain't defamation. Neither are opinions. Everyone's innocent till proven guilty. Please do not contact anybody mentioned in this video. That's not the purpose of my videos. The video is meant to report on matters of public concern and give my opinion. I did see the van map updates and I did a full analysis pointing out the discrepancies. Thank you for the $1.99. Thank you to Fly Chomper Fly for the $2. You are amazing. Thank you. Thank you. Thank you. Thank you. All right, I'm getting out from under this light. Love you, mean it. Okay, bye.